The Lordship, I may be pardoned to mention. The Lordship, I may be pardoned to mention. PRLMC number 3498 of 24. The Lordship has directed to list the matter immediately after service of Dusty notice. The Dusty notice has been served to the.
Give the memo.
Fine, give it.
Give the memo.
Signal of 671 of 24 month. My lord was placed to alert direct to early hearing subject to filing of criminal paper. We have already filed the paper. So.
This is a matrimonial criminal appeal of 2018 arising out of business case. The petitioner has been dismissed from service for 8 years. The matter has not been come in the report. Court has directed subject to outcome of the appeal.
Obviously, subject to outcome only.
Let it
Give, we'll see.
Otherwise, criminal appeal. Otherwise, we retire from service.
There are people, those who are in the verge of death, their matters are not being taken up. You retire the office.
Today,
That's right, but urgency I have to see. Give it.
Give
the memo, we'll see. Yes, Mr. Sharma.
305 millions. Above the period I have already undergone for bail millions. Every day after tomorrow.
Mr. Sharma is back.
Question of stay. Challenge to the 24 by this.
I have granted stay. I have granted. There must be some merit in it. Otherwise, I generally prefer to dispute. Anyway.
I'm for informant. 302 offense.
Okay. What in bail has been granted?
No, my lord. Metro stayed in CRLMC by the petitioner because 311 petition was filed by the informant. So the petitioner come to this court in a CRLMC state. My lord, I'm for informant.
Look at this. Yes.
Kindly witness.
Yes.
criminal appeal matter.
Why are you so pessimistic in the morning? I am hopeful that I will reach there.
No, it has not been listed.
It's not listed. In the weekly, it must be there.
Friday, your lordship said that it will be listed at 3:30.
Okay. What the vigilance councils want that all the matters should be listed now, listed in one day. They are going to meet me in the.
Because I had mentioned.
I know. In the priority space, I'll take it. Tell them to meet. Huh? Number you have given.
289 up to
280. Yes.
Hearing of criminal appeal items.
Weekly list.
Yes.
Let us finish first this. Be ready.
Yes.
Once the moment I finish, I'll start
8
taking up.
years inside the custody. I will obtain this from this.
My lord, I am Sarkar.
Hmm.
2022 meter. Offense is a 354 read with the SCST Act.
What do you want?
My lord, sir, compromise joint affidavit has been filed the day after tomorrow. Compromise has been filed a joint affidavit.
What are the offences you say?
354 and 3 SCST Act.
Convicted.
No.
Oh.
Discharge petition against Asifele. That is stay.
Bring the parties. Bring the parties. Bring the parties.
My lord, petitioner asibe, say informant.
No. Without that,
Government
whenever
servant.
maybe whatever, I don't know.
Link there.
Anyway, that is also appearance. That is also an appearance. Not physically not required. Online.
Link there.
Friday.
Your lordship.
Maybe fine. At least 54 items.
Today's list.
Yes, second list, 54.
What do you want?
Maybe taken up today.
Let me finish it up. If you waste half an hour in this,
Last 3 weeks.
this list is there. I'll take up one after another. Let me finish the miscellaneous matters first. Hold on. Don't be pessimistic in the morning. I'm very positive that I'll take it up all the best. Let us see.
The Lord's kind permission, my lord. Item not 100 of today's list, man. In this case, I am appealing for the petition of husband. My lord and is appealing for the wife.
In the supplementary or?
To supplement it.
Yes.
Totally.
Some area there.
I have obtained instruction. Maybe I have taken consent. Maybe taken up on next week. My lord, any date. One day.
Oh, I didn't put this. Yes.
Interim order to continue.
They have used item 97. Last
Who is appearing for the other side?
petitioner.
Mr. Sharma, senior advocate Mr. Sharma.
हाँ.
Last of the minor director of the substitution instruction.
Next
That
week,
you have to
next
attend
week.
next week.
But I don't know whether he will oppose or not. I don't know.
Next week.
There, these two lawyers are there. 97 like doctor.
97.
97. Okay.
52 minor. I am for the appellant. It will come 1 week after minor.
Oh, are you enjoying stay?
No, my lord.
No. Okay, adjourn कर दे. September order. Yes.
Tribunal appeal actually also specifically adjournment last proceeding.
Give the memo. Give the memo.
Yes.
Give the memo.
After 4 years, he is
Give the memos. Give the memos. Give the memo. Yes. Yes. Start. Give the memo. Yes. Next. First. Yes. Nothing. Move on. No one. No one is. Yes. Yes.
for report, status report. Item 1,
Appellant is died, your lordship.
Right.
Yes.
The अच्छा sole appellant Kalidas. Kalidas has expired about 15 to 9 pursuant to the order dated so and so. The state council has placed on record a report dated 3/8/2026 issued by the IIC Begunia police station. Police station. As per the report, the sole appellant Kalidas has already expired 12 to 15 years ago. At the same time, respondent number 3 and 4 have also expired. In view of the same, the appeal stands debated. 2007 applications by the deceased appellant, the LRs of the deceased appellant or the near relatives. Yes.
item 2,
Yes, report. What is this report?
Your lordship, item 2 report has not come, but I contacted over phone with the appellant.
What is this report?
No, সেটা no. A report, এটা পুରୁଣା report ଆସିନି, ସେ ତା ନୂଆ ଆଡ୍ରେସ ଟା କଟକର ଦେଇଛନ୍ତି, but he is alive. ଯାହା ଫୋନରେ କଣ୍ଟାକ୍ଟ କଲି କିନ୍ତୁ but ତାର ଫିଜିକାଲ ଭେରିଫିକେସନ ଟା ହେଇନି. He will come on right now he is in Kolkata. He will back by 21, 20, 25, 22nd.
He is alive.
He is alive. କିନ୍ତୁ ତାର ଡକୁମେଣ୍ଟ କିଛି ନାହିଁ.
It's all right. It is reported by the state council that the sole appellant in the present case, present case is alive. This is against acquittal.
Yes, your lordship.
Alive, and the matter is ready for the appeal is ready for hearing. Ready for hearing. Release the matter. Immediate probability. Top, yeah? Top. Yes. Yes.
item 3,
Diagnose. What is happening? Item 3, yeah? The pursuant to the order dated 23/7/2026, a report has been filed, a report dated 3/8/26 by IIC for the rest of police has been placed on record. As per the report, the sole appellant Nirmala Soragli has died on 15/4/2018. That certificate is also enclosed with the death certificate. Not that. Death certificate is also enclosed with the report. The same is taken on record. In view of the same, the appeal stands submitted in the absence of any application by the LRs of the deceased or any relatives. Yes, sir.
item 4,
Fourth, you know, not traceable. Pass over, we have it. Pass over.
4. You are ready? Pass over, okay.
my lord, here Union of India is the appellant, my lord.
Union of India, item 4.
Yes, your lordship, item 4.
Your Lordship,
What is this? What is this matter?
against acquittal, my lord.
Against acquittal?
Yes.
Offense-
My lord, a copy is not available.
Offenses?
Offenses, my lord,
Let's see. What are the offenses? Why Union of India has come?
says.
What are the offenses?
It says.
Conviction?
Yes.
There is a conviction. What do you want?
No, conviction acquittal is
Gold Control Act.
acquittal.
No, no.
Hmm?
Therefore, hold that the prosecution has succeeded to prove the case of the accused beyond all reasonable doubt, and accordingly, the accused is found guilty of offense under 135(1)(1) of the Customs Act and 85(2) of gold.
Your Lordship, allow me to take a copy.
Take soft copy and include in the list, weekly list. I will not adjourn next time.
My lord, yes.
Yes.
Item 5. My name may be noted.
Yes.
Purnakar Naik.
Yes, next. Purnakar Naik. Name may be.
Item 5.
5 years.
Item already submitted last.
5. What is the report?
Report applicant is alive, Your Lordship. But
The-
some of the respondents are alive, and out of 19 respondents, 3 of them are died.
Okay. What are the offenses? This taken pursuant to the order dated 23/7/2026, the State Council has obtained instruction and submits that the sole appellant is alive, and therefore the appeal is ready for hearing. And you are appealing?
Therefore, the respondent.
Respondent, who is appearing for the, it is seen from the record that consistently, continuously, none has appeared for the appellant, therefore, she needs to go. So-and-so is, so-and-so is appointed as a case to appeal court, include this matter in the weekly list for disposal. Yes.
Item 6.
Yes.
Item 6, Your Lordship, I don't have the copy. I will take copy and instruction at the next week.
Okay. The order dated 19/5/2026 has not been complied. Mr. Das seeks 1 week time. Please the matter next week. Next week, next Tuesday. Next Tuesday.
Yes.
Yes.
Item 7.
Your Lordship. Item 1, item 6, nothing matter stands submitted against respondent number 1.
Oh, I am interested in appellant. Get the appellant. If you
Yes.
then only it will be able to. Yes.
Right.
7.
Item 7.
7 alive, Your Lordship.
Like, pursuant to the order dated, order dated 19/5/2026, a report dated 4/8/26 by IIC Salipur was placed on the spot. So as per the report, the sole appellant as well as the respondents are alive. The appeal is ready for hearing. However, no, ready for hearing, including remaining weeklies.
But in that item number 4,
Hmm.
what's the fix to next week?
4. Yes,
If I may be permitted, I will take the LCR from
yes, you can take.
pen drive.
That order I have passed.
It was passed.
Top of Mr. Rao appeals for Mr. Rao appeals for the respondent and submits that he may be permitted to obtain the soft copy of the trial court records. The instructing counsel of Mr. Rao may obtain the soft copy. Yes.
Item 8.
Item 8, expired, Your Lordship.
Expect pursuant to the order dated as 19/5/2026, the report dated 3/8/2026 by IIC Town PS Sambalpur, who has been placed on record. As per the report, this whole appellant Banwari Lal Modi It expired on 9/1/2022. And the certificate is also includes, which is taken out of her in the absence of any application by the certificate appellant or his relative, near relatives. The appeal stands abated. Yes.
Item 9.
Your lordship will take some time.
Okay. The order dated of 20th March 2020. No, sorry. 29. There is no order itself. 29/4/2026 has not yet been complied. Mr. Das seeks one more week time to comply the same. Please the matter next Tuesday. Yes.
Item 10.
10 appellant expired. Right.
Pursuant to the order dated 19/5/2026, a report dated 3/8/2026 by IIC Youngers of the police station has been placed on record. As per the report, the sole appellant Gopal Naik has already expired.
Right.
And already expired. And it is also reported that the respondent number 3, respondent 2 and 3 have also expired long way. The report is taken on record in the absence of any application. Will be appropriate. Large subsidies under or relative under section 394 CRPC, the appeal stands abated. Yes.
Item 11.
11 appellant expired.
The appeal expired.
Yes, sir.
By
Don't think-
last 10 years. I don't. Pursuant to the order dated 19/5/2026, report dated 4/8/2026 by IIT Bhadra Police Station has been placed on record. As per the report, the sole appellant Anam Charan Biswal
Hon'Ble Charan Mishra, it's in July.
has expired on 25/7/2026. The 2026. The while under treatment in the Apollo Hospital, Bhubaneswar. In the absence of any application also abated. Yes.
Item 12.
We both are alive, your lordship.
Alive. As per the pursuant to the order dated 19/5/2026, report dated 4/8/2026 by IIC Tihidi PS station. PS has been placed on record. As per the report, the appellant as well as the respondents are alive. The appeal is ready for hearing. However, it is seen from the record that none has been appearing in the appeal, hence so you are appearing for which item?
12 here.
This is 12.
Yes, your lordship.
Yeah. Why don't you tell you are appearing for whom?
Appellant, your lordship.
Huh?
I'm appealing for asking.
No, you must open the mouth. I am appointing MIK script. Nobody is there. So,
Pardon.
hey, go on, right? Enter your appearance. Yes.
Item 13.
Alive.
Appellant expired, your lordship.
Expired.
Yes, your lordship.
Why are you saying alive? Appellant namely so has died. Yes. Pursuant to the order dated 19/5/2025, report dated 3/8/2026 by IIT in Bhandari Pokri PS has been placed on record. As per the report, this whole appellant Vichitrananda Naik has expired about 1 year back. The report is taken on record. In the absence of, and it is also reported that the respondent number 3 has also expired. The report is taken on record in the absence of any application from the Yes.
14.
14 appellant expired, your lordship.
I'm appearing for the respondent, but there is no instance.
Okay. Pursuant to the order dated 19/5/2026, a report dated 3/8/2026 by IIC Durga Bajar PS has been placed on record. As per the report, the sole appellant, Dr. Mirza Iqbal Bey, has expired on 21/5/2021. The death certificate is also enclosed with the report, which is taken on record in the absence of any people who stand civilly. Yes.
15.
Yes.
15 requires some time next week as it is respondent manakar khal dei diche appellant rohi
Okay.
dein
The order dated 19/5/2026 has not yet been compiled. It starts with 1 week adjournment. Please the matter next week. Yes, sir.
16.
16 appellant died.
And pursuant to the order dated 19/5/2026, a report dated 3/8/2026 by Chhatrapur, IIC Chhatrapur Police Station has been placed on record. As per the report, the sole appellant Dasu has expired on 16/11/2020. The death certificate is also enclosed with the report, which is taken on record in the absence of an application 394. Awaited. Yes.
17.
Appellant alive LLC, but respondent died in this case.
Sole respondent. Only one
Yes, sir,
respondent.
only one.
Right. This is an appeal against the judgment of acquittal. Is in judgment appeal? You are appealing for the appellant?
Appellant.
Yes.
I'm appealing for respondent.
Huh?
I'm appealing for respondent.
Respondent. Okay. Judgment of acquittal dated from so. On 19/5/2026, this court has directed the state council to obtain the whereabout, well-being and well-being of the appellant as well as the status. Whereabout, well-being and the status of appellant as well as respondent. Pursuant to the said direction, the IIC Baripada PS has placed on record a report dated 3/8/2026. As per the report, although the appellant is alive, however, the sole respondent accused, Vijay Kumar Barik, has already expired. The certificate, the death certificate of the said deceased respondent is also placed on record. In view of the aforementioned development, nothing survives in the appeal. Accordingly, appeal is disposed of, being infractious. Yes.
18.
18 Suna President is not traceable, your lordship. Reported just, I received just now,
Not traceable.
not traceable.
Pursuant to the order dated 19/5/2026, the state council is obtained an oral instruction. As per the instruction, the whereabout of the appellant as well as the respondents traceable, not found traceable. Hence, the appeal be heard on its merit, since none has appeared for both the respondent, appellant and respondent shown for upon history, include this appeal for hearing in the weekly list. Yes.
19.
19.
Yes.
19 and need some time, as senior.
Okay. Order dated 19/5/2026 has not been complied. Mr. Das seeks one more week adjournment for compliance of the same. Release the matter next Tuesday. Yes.
20.
20 means both appellant and the respondent not traceable.
Not traceable. Pursuant to the order dated 19/5/2026, a report from Bodaville Police Station dated 4/5/2026 placed on record. As per the report, neither the appellant nor the respondents are traceable. The appeal is otherwise ready for hearing. Since none has appealed for the appellant as well as the respondent, include the matter in the weekly list for final disclosure. Yes.
21.
21 appellant expired.
Pursuant to the order dated 19/5/2026, a report from report dated 4/8/2026 by IIC Gangapur PS has been placed on record. As per the report, the sole appellant Lakshmi Narayan Mahapatra has expired on 12th July 2022, and the death certificate, 12th July 2. The report is taken on record in the absence of any application on behalf of the deceased counsel. The bill stands awaited. Yes.
22 appellant died, Your Lordship.
Pursuant to the order dated 19/5/2026, a report dated 4/8/2026 by Nimahandi PS IIC Nepal has been placed on record. As per the report, the sole appellant Devraj Samant has already expired. The report is taken on record in the absence of any. And it is also reported that nine respondents have also expired in the meantime. The report is taken on record and the absence of any application on behalf of your claim to the 390 also. Awaited. Yes.
23 appellant died, Your Lordship.
And pursuant to the order dated 19/5/2026, a report dated 3/8/2026 by Balikuda Police Station has been placed on record. As per the report, the sole appellant Dandi Marana has already expired in the year 2023. The report also indicates that the respondent number 2 has also expired in the year 2024. The report is taken on record in the absence of any application of the deceased appellant under section 394. So stands awaited. Yes.
24 appellant died, Your Lordship.
Pursuant to the order dated 19/5/2026, a report dated 6/8/2026 by Banki PS has been placed on record. As per the report, the sole appellant Navokishore Pratihari has expired 6 years back during the COVID period. The report is taken on record and the absence of any application stands awaited. Yes. Yes.
25.
Yes.
25, Your Lordship. Lordship, appellant is convicted under section 10 of POCSO for 7 years, Your Lordship.
Notice was issued.
No, Your Lordship. The press.
It has not yet been admitted. Okay. Okay, admit. What was this order mean?
The notice is sufficient, Your Lordship.
Notice was issued.
Yes.
Okay. Pursuant to the order dated 7/3/2025, notice on the victim of the informant has already been effected. Effected. The Siddhartha is not called reproof despite effective service. Since nobody entered appearance. Taken on apart, nobody has entered appearance. So is appointed in my case to access the court. Next report. Appeal admitted, call for TCR, and realization of fine. Realization of fine is there. Yes. Yes, sir. Realization of fine. Take. And in bail application. Okay, we heard once what is the sentence?
7 years, Your Lordship.
Bail application, release the bail application. Once the TCR is issued. Yes. Yes, next.
26.
Substantive sentence 20 years under section 376 3 IPC. The other allied offences. POCSO is also there. Victim already appeared voluntarily. But appeal has not yet been admitted.
Okay, admit. Is there any delay?
Well, there is no delay.
Admit. Call for the court record. Since one of the offences also and the notice to the victim of the informant after the receipt of the bail application. Yes.
Obliged.
27th,
Yes.
my lord. The prisoner is convicted under 13(1)(d) and 13(2) of the Prevention
This
of
sentence,
3 years under section 13(1), 2 years under section 7 PC Act.
389, 3 benefit was granted.
3 years under section 13(1)(d). And he has mentioned in bail application that he was on bail throughout the trial.
Admit, call for record. Every application record. The appellant was.
My name may be kindly be reflected in the order.
Let me complete the sentence first. The appellant was on bail during the trial. After the sentence in court, after the conviction, the sentence in court, by exercising the power under section 329(3) of CRPC, and granted free suspend the sentence till the appeal is filed. But it is filed. Appeal is filed regarding to the period of custody. Regarding to the nature of evidence, since the appellant was throughout bail during the trial, and going to suspend the sentence pending the appeal, accordingly granted bail. Yes.
The appellant, besides this appellant, another person was also convicted and
Did he
sentenced.
file any appeal?
I did not file this.
Let him file the appeal, we'll see.
Yes, already been released on.
Already. Can you give the appeal number? Can you give the appeal number?
I will get it afterward. हाँ दे दे.
Tag करियो.
तारा बहुत आगे सर लिख. मुझे दे दे. ता दे दे.
Give. He gives the number. Tag. Sanjay, Mr. Sanjay Kumar Das, PPSC. Yes.
28,
Yes. Yes, madam.
I am received the application the judgment. Bar of judgment dated 12/5/2026.
It has not yet been admitted.
No, my lord.
Okay. Admit.
Appeal has not been yet
Okay.
admitted.
Admit. Call for a PCR. Since one of the offences is POXO, I issue notice to the informant of the victim. Interrupt the PCR is. Yes, I have allowed your application for realization. Bail, I have issued notice because POXO is there.
The POSCO acquitted.
Mhm.
POSCO section 10(12) of POSCO Act, trial court acquitted me.
You have been convicted for which offence then?
Under section 363, 341, 506.
Okay, only simply issue notice. Mr. Das accepts notice. Means the matter after the TCR is come. Yes. You respond it now.
My lord, bail
I will hear him. There is-
arrest कर दोगे तो police.
No, there is nothing. You have not filed any evidence. Nothing is there. Except impugn order, there is nothing. How will I decide myself?
केतल arrest कर दो.
Either you file deposition or I'll have to call for the TCR.
हाँ, LCR call for deposition.
That's what I'm saying. The moment it comes, I'll list it. You mentioned. What is the sentence?
Sentence is 2 years.
Oh, 2 years. Then I'll have to fix. Short sentence. Okay. List it on 25th. 25th.
25th.
20.
Okay.
Okay.
29,
If you have, madam, if you have deposition, you please file.
My lord.
So that we will not wait for the TCR. We will decide it.
My lord.
If you do you have the deposition with you?
Time କରିବାକୁ ପଡିବ, not legible. The legible copy ଟା ଦେବାକୁ ପଡିବ.
Or TCR will take little time, you know. So therefore, TCR, the trial court record will take a little time.
LCR କୋରାପୁଟ ଜୟପୁରରୁ ଆସିବ.
Therefore, if you have deposition, give me. I'll take it up.
Deposition copy जोटा अच्छी होती legible होची दे देना हम सेम सर तो जल्दी ना.
By 25th, you also file it.
My lord.
By 25th.
If trial court record comes, it's all right. Otherwise, I will rely upon your. Okay. Yes.
29,
29, my lord. My lord, 1 year conviction, my lord. And
1 year conviction.
yes, my lord, he is on bail, my lord. This is the certified copy.
Offense?
354,
3?
355 and 324, my lord.
What do you say? 1 year sentence, 389 benefit, right now. Petitioner is convicted for offense also and sentenced to undergo RI for 1 year. When the judgment was passed, the judgment of sentence, when the sentence order was passed by the trial court on 18/7/2026, the sentence was suspended. How much suspended under section 389 CRPC till the appeal is filed? Regarding to the sort regarding it to the period of sentence and the nature of granted. Yes. Yes.
My lord, stay realization of fine.
Stay realization of fine. Okay. 30.
Is it fresh admission matter also?
Yes.
The appellant is convicted on section 4 and 6 of the POCSO Act also,
Okay.
with other offences.
Call for trial court record and stay realization of fine, and insofar as I is concerned, you should notice to one of the offences also, we should notice to the informant of the victim. Yes. Please the matter.
31.
Yes.
May I visit one of the conviction is on post marriage. Accident.
Okay, same order. Same order. Yes.
And it's only for
Yes, same order.
notice through marriage.
Yes, yes.
Matrimonial PS.
Yes. Next.
But I saw that it is 60 or 4.
What is the sentence?
Sentence notice out of the 3 years and a half months.
That's all right. Yes.
Where the main accusation is the same trial. He has been unnecessary entitlement.
Let's see. Yes.
32.
32.
Obligation.
Item 32.
Pass it over.
Password. Yes.
33.
Yes. 33.
I have filed a written note of society something. Can they respond to that, sir? I will place my case.
Mr. Sangram Das.
Yes,
Sangram Das. Okay.
I beg to submit my written note, my lord. I've given a copy already.
So what do you want? You want an adjournment or what?
No. I want to place my written submissions.
Yes, yes.
That is already on record.
Yes, yes.
May I place it, my lord?
Yes, yes.
Petitioner is the housewife or husband is a public servant.
छोट छोट मैटर अच्छी आमे लॉन्च पर करें.
I'll just pass over. He's correct. I'll run through the list. Then after the end, I'll take it up.
My difficulties I have got it. Matrimonial matter of one of my documents.
You accommodate. You go and do it and come.
मैट्रिमोनियल वेट कर दो. इटा इम्पोर्टेंट.
Matrimonial is one of my colleagues of this bar.
It's all right. You do that matter and come.
Hon'Ble case for me.
It's all right. You do that and come. No problem. I'll pass it over. Because there are a lot of small matters. I'll just run through the list. Okay? Okay. 34. Yes. Yes.
I please your lordship. Because in this matter, we are praying for a direction to the honorable, praying for direction to the state consumer forum for expeditious disposal of the FA number 47 of 24.
Why? Why your case will be given priority? Because you can afford to come to High Court. Therefore.
No, my lord, the respondent has not been appearing in the case since.
But why should your appeal will be taken in priority wise?
My lord, because the respondent has taken possession of my vehicle, and regarding that vehicle is the the major source of income of my family, and they are not appearing. They also did not appear in the complaint case, and now they are not appearing in the FA for long. Recently they appeared. Then on the last date also, their counsel said that his name may be deleted, and now it is posted to 2nd of September, and no fresh counsel has appeared for them. In this way, they are delaying the matter, and because my livelihood is dependent on the vehicle only, that is why I am praying for expeditious.
Relying upon the proceeding before the State Commission, State Consumer Commission FA number 67 of 2024, placed as annexure 1 to the petition. The petitioner is seeking a direction from this court for direction from this court to the State Consumer Redressal Commission for disposal of the first his first appeal within the stipulated time frame. The counsel appealing for the petitioner submits that the only livelihood, the vehicle, this was a commercial vehicle.
Yes, construction equipment vehicle.
The commercial vehicle purchased by borrowing loan, na?
Yes, ma'am.
Loan from the respondent has been taken over by the respondent illegally, for which he has initiated the consumer dispute. Due to pendency of the appeal, his livelihood is affected. Therefore, he seeks a direction from this court for a further approach. Since speedy justice is statutory constitutional statutory right, it is obligatory on the part of the judicial forums to dispose of every case as expeditiously as possible. Therefore, the prayer made by the petitioner being innocent is allowed. The appellant, as the State Consumer Forum is requested to do well to see that the appeal number 67 of 2024 is disposed of as expeditiously as possible. With this observation, the petition is disposed of. Yes.
35.
Obligation.
Yes.
Yeah, please, Your Lordship. No, it's also husband died and you working as a security guard. So somehow,
You are also seeking early disposal. You are also seeking early disposal. 2025 consumer dispute.
Sir, dispute pending. Sir, should I early disposal?
Why 2025? There are matters pending.
No, sir, consumer forum, no, sir, ADM pakre pending. District Consumer Protection Officer pakre pending.
This is consumer dispute. Miss case number. Where is that?
Sorry, no. Consumer ADM pakre pending, sir. OP number 1 pakre.
Where is that? Let us see.
ମୋ କ୍ଲେମ ଟା ସାର୍ ସେ ନୋଟିସ ହେଇଛି ଖାଲି ଏତିକିରେ ରହିଛି ସେ ନୋଟିସ ହେଇଛି ପେଜ 14 14
ADM Nagar.
ସାର୍ ଏ early disposal sir.
Right now, by invoking the reductions of the court, the petitioner is seeking following the speedy disposal of the ADM Nagar is directed to do to see that dispose of bail. The miss case number 1 of 2025 which is disposed of bail expeditiously possible.
Like
Yes.
আমার কপি ওটা দিতে হবে
Yes.
কপি ওটা যখন দেখবেন কপি ওটা ফিল করছেন কপি
ठीक है दे दो. Yes. Yes. Next.
36.
Item 36, my lord, I pray for next week. I pray for next week. State has filed this appeal, my lord.
Appeal against what?
Against acquittal. Against acquittal.
You tell me what is the purpose?
I need to discuss with the IO. I have called and due to August 15, he has not come. And so 1 week after.
Now you have to see what are the offense? What are the offense? Offenses are?
My lord, offense under section.
NDPS.
NDPS, my lord.
See whether you have complied with the.
And
It is very detailed order
huge amount, my lord.
running to 60 pages.
3,157 kg. So whether 42 has been compliant or not, that is the issue.
The quantity may be more, If the quantity of more, then the prosecution should be more careful about it. If it is acquitted, just see what are the reasoning of acquittal.
So reasoning that he has not followed the section 42 and 50.
Then
So I have to.
you not comply. It to
So I have
benefit has to go.
I have to.
What is
discuss-
perversity about it?
I have to discuss with the ISO. He has not able to come because of August.
The next week.
Next
See, you have not complied 42. The recovery is 300 kilo.
3,000.
Then you should have been more careful in these kind of cases.
57 kg.
Huh?
3,157.
3,000 kilo. And the 42 is not complied. Just see.
So next week.
And some departmental proceedings should be initiated against the IO. 3,000 kilos
3,150 kg.
and acquitted on the ground that 42 is not compliant.
Not compliant.
To next week.
Next week.
Come with the deposition.
Yes.
Yes.
37.
37, Lordship, this is the case where Lordship kindly turns the order dated 9th of April, order number 8, Lordship. Here is a case, Lordship, the opposite party number 2, while being granted bail, he has assured that he will pay the rest of the amount. But since 24, Lordship kindly turn to the page, on page 10 of the CLMA, that is the order passed by Lordship only, 12th of March 2024. Since then, he's just playing hide and seek. Several times adjournment is given. Last occasion, while Lordship were dealing with the matter.
He is appearing.
Yes, he is appearing. Last occasion, he was in person.
I am appearing this.
Yes, he is.
Yes.
Lordship,
Yes, Mr. Bhakti, what do you say?
Lordship, last occasion, Your Honor directed to appear the opposite party number 2 and opposite party number 2 appear before this court. Sir, in regarding the non-complying of the court's order, I submitted that now the case is in the flag state, IO is to be cross-examined. And out of the transaction, I have given the 3 checks. The check regarding that the FIR has been registered. And now the complainant and his wife and his daughter filed a NI Act case 138 NI Act case against me, which is chance to be recovery. And if you give the money, I already given the 5 lakhs.
No, that's not that you may have a good case, but the problem is you yourself have given a undertaking to the court that I'll deposit and took the bail. Thereafter, you make all kind of submissions now.
Sir, Lordship, may I kindly wants to attract this court, the para number 5. If Your Honor, I have given already 5 lakhs rupees of cash. If Honor, I directed para number 5 in my affidavit.
Your para number 5 of your
Affidavit, file as per the
affidavit.
order of this honorable court.
The opposite party assured 3 lakh rupees.
Sir, my ambition is that due to my financial crisis,
Later before the court below within a period of 6 months. Yes.
6 months.
sir, my submission was that I have already given the 5 lakhs rupees. 3 check bounce cases pending against me regarding that matter. And the case is flag of this trial stage. If Honor directed to me, I will deposit that money before this honorable court in the name of the court, not to the informant. If it will deposit,
Do it.
Again, they will pay for time. They are again playing it.
It will not be given to you, he will deposit.
That is no issue. They deposited on in a interest-bearing account.
Before trial court, you deposit.
right, sir, I will deposit and give some time.
It shall not be dispersed till the case is disposed of.
In any interest-bearing account, that will help also.
Sir, interest, I will deposit in the court. Why should I give interest?
No. What he says is let it be invested in an interest-bearing account, and after the disposal, it will be decided.
Decided, no issues.
You will get interest on that.
Sir, I will deposit in the court's account.
Correct, fine.
So,
Yes.
a time limit may fix because 7 days he may do that.
Sir, maybe please for a 1 month time to deposit.
1 month time. Since last 2 years he is playing hide and seek. Again 1 month time.
It is a vast amount, 47 lakhs. 5 lakhs already deposited.
नहीं थे ना 47 लाख देखना थे लेकिन तो नहीं थे ना.
Decided, it will be decided at the time of trial.
The respondent, na?
Opit number 2.
Okay. While disposing of the bail application, BLAP number 667 of 24, of bail application of opposite party number 2, being BLAPL number so and so on 12/3/2024, this court, the opposite party was granted bail by this court by order dated 12/3/2024 in BLAP numbers 867 of 2024. While the matter was heard, the counsel appearing for the opposite party voluntarily made a statement that he would be depositing 5 lakhs of it.
Paid 5. Out of 47 lakhs 700.
Out
So
of
70,000.
out of 47,000,
47 lakhs 70,000.
70,000, he would be paying 5 lakhs rupees.
Out of that 5 lakhs
5
paid.
lakhs. It appears that he had deposited only 3 lakhs.
No, he had paid 5 lakhs rupees. 5 lakhs rupees he has paid on 5th of January 2024.
And the rest of
Rest amount has not been paid.
he said that the entire amount
The
is
rest amount, he says that he will deposit rest of the amount. That is 42 lakhs 75,000. He will deposit.
no,
What
no.
he says.
12th, where is that order? 12th order for me.
12.
1 minute.
Let's see, page 10. Let's see.
1 minute.
Okay,
Right.
let's see brief only.
No, it's all right. Only. Then, Tarabu. The entire disputed amount of 47 lakhs 70,000 rupees. 70,000 rupees. And out of the same amount, he deposited 5 lakh rupees. 5 lakh rupees. It is contended by Mr. Mahapatra, Learned Counsel for the appellant, that despite the petitioner, that despite such undertaking given to the court, after the bail was granted, the opposite party number 2 has not deposited any amount. Therefore, by way of the present petition, he is seeking to recall the order dated 12/3/2024. The matter was heard on many occasions. And lastly, on 9/4/2026, the appellant, as the petitioner himself appeared before this court and has undertaken to deposit the amount. Mr. Mohanty, Tanmay Kumar Mohanty, and counsel appearing for the opposite party on instruction submits that the opposite party number 2 shall deposit the remaining amount before this court. However, the same amount shall not be disbursed to the petitioner. Disbursed to the petitioners. Regarding head to the statement made by the counsel for the opposite party, the present petition is disposed of with a direction to the opposite party to deposit the remaining amount of disputed amount before this court, and this court, registry of this court. The same shall be invested in an interest-bearing account, of account. However, the amount to be deposited by the opposite party shall not be disbursed to the petitioner. The disbursement of the amount to be deposited by the opposite party number 2 shall be decided after the disposal of the disposal of the trial. Trial
Yes.
pending in which court?
Pending before that STM court.
Trial in
Pending.
Lord JMFC 4.
Koda
Bhubaneswar.
case 5 of 2024 pending in the court of
Lord JMFC 4. Roman 4. Bhubaneswar Kota.
and the amount the opposite party number 2 shall deposit the same within a 1 month. 1 month. With this observation, the petition is disposed of. Yes.
Lord JMFC contained some period.
1 month.
1 month time.
Yes.
In the event he fails, then necessary of correspondence.
Obviously, it's false.
That obviously
One, see, IO has been now examined. By the end of 1 month, I think the trial will be over.
It should be.
Trial will be
In the event he fails, then something should be there. Otherwise, there will be no check
Liberty is
also.
granted to move appropriate application in the event the opposite party to pay should be put in. Yes, grateful. Yes.
38.
We have no instructions in the method.
No instruction means
We are unable to contact the counsel
for the
parties as well as the
petitioner
local.
submits that she has no instruction in this case. Accordingly, she stands dismissed. Yes.
Objection.
39.
Lordship, in item 39, we have filed an interim application for substitution, Your Lordship.
Substitution of what?
Lordship, appellant died on 14/8/2024, for which we have filed the substitution petition to substitute his wife as the appellant.
The sole appellant has expired on
Died on 14/8/2024.
2024. The wife of the deceased appellant has moved this present application seeking substitution to prosecute the appeal. For the reasons stated in the application, the same is allowed. The Meena Dasana, wife of late Nupa Dasana, is implemented as appellant in the present case. Remand removal party is filed by the newly substituted appellant. Leaves the matter for disposal. This is the appeal of which year leaves the appeal for disposal in the list. Yes. Yes.
Grateful.
My lord, a response from the vigilance side is required, my lord. I have already filed the IH.
IF for?
IF for, my lord, for recalling of order.
My Lord,
Form D, flag D, my
as
lord.
per my undertaking, I have already
D for D.
My lord. I number 197726.
19.
For recalling of order dated so and so. And another my lord, the 191199.
What is this order?
My Lord, what has happened, my Lordship, on 15/7/2024, the appeal was dismissed as abated.
Sorry?
Dismissed was abated. The man
Appeal abated, yes.
Yes, my Lord. Submitted on 15/7/2024.
Yes.
Now they have filed 4 applications. One for substitution, one for recalling the order of abatement, one for set aside the order of abatement, one for
Why so many applications? All the applications. Why so many applications?
And I have already filed my objections to all the 4 applications. Today I am serving.
What objection to this? He is right.
No, my Lordship, your Lordship will go through. I will argue the matter.
What objection to the setting aside of abatement?
No, my Lord.
In fact, 394 doesn't have a limitation in true sense.
Yes.
It only says that within 1 month of death, it will be abated.
Yes.
And thereafter removes an application for abatement. Setting aside.
It died in 2021. It was abated in the year 2024. And my Lordship, they are filing the setting aside abatement in 2026. It is after 1,790 days delay.
It's all right, William.
And my Lordship, so far as substitution, all the legal heirs, they have filed this application. This is the confiscation application, appeal. My Lordship, I have got the objection. Because so far as the confiscation appeal is concerned, there is no provision for substitution. Because the scheduled properties which has been thrown in the confiscation order.
What happened to the appeal? Criminal appeal?
That has been abated, my Lord. But that criminal appeal, it was abated during the trial.
Trial?
Yes,
then it has to be, it is contingent upon the conviction.
Yes.
Confiscation is contingent upon the conviction.
Yes.
And the conviction you can't secure because he had died.
Yes, ma'am.
And the property will take it. What is this?
No, my Lord, there is
you have to be reasonable.
Yes, my Lord, I know it, but there is no.
Confiscation is contingent upon your conviction.
My Lord, only my.
And during trial, the accused dies.
Yes, ma'am.
The confiscation order can't stand because they have to substitute it, they have to contest it.
Yes.
On merit.
And
you can't have the cake and eat it also.
No, my Lord, so far as the confiscation, final order of confiscation is concerned, there is scheduled properties which is to be confiscated. And so far as the scheduled properties are concerned, nothing belongs to those legal heirs.
That is on merit, sir. That is on merit you can argue.
Yes.
That is on merit you can argue. Nobody can stop him. But substitution has to be there.
That objection I have given.
You can argue on merits.
Yes.
You can say that whatever you want to argue that it is open for you. But how can you stop
Because in
substitution?
My lordship, in a judicial process, it has been declared as the ill-gotten property, and those properties does not belong to the legal heirs. Now they are claiming after the death of father and mother.
I don't know whether it may be ancestral property, maybe the inheritance right might have gone, and maybe some will. I don't know all these things. That will be heard when appeal is heard.
Appeal.
I leave the appeal for hearing by substituting them.
Yes,
Get ready with the appeal.
and my lordship, so far as their applications are concerned, there are many things to be noted. Because my lordship, I am sending one copy.
Which application you are talking about? IN number?
My lordship, an application for a IN number 1997 may kindly be seen.
1997.
Yes.
Yes. Yes.
My lordship, that petition
Yes.
1997 of 2026.
Which para?
My lordship, the first thing in the last, my lordship, affidavit may be seen. Affidavit person.
Yes.
My lordship, it has been
Siddharth Sankar Rautraj.
just below that, Gangaram Behra, he has put the signature 17/2/26, and it has been struck down. 17/2/26.
All these things.
No, my lordship,
70 to 25.
25, and it has been
26 all what?
Nahi, Katichandi.
You know what kind of notary signed and all this thing.
Tapare out a petition ne 17/2/26.
Are you serious about all these things?
Nahi, taku phone 5.
Let us come to the main paper. Unnecessary notary has signed something. All these things is neither here nor there. Let us come to the merits. I will allow the application. I'll set it for hearing. Get ready.
Yes, ma'am.
The 1, 2, 3. How many applications you have moved? I know. The one.
My lord, my formal objections.
Yes, 1977 of 2020.
Perhaps all my objections have not come to the board.
It's not. So why the sole appellant? No, this is the appeal arising out of confiscation, judgment of confiscation passed by the authorized official, Special Court Bhubaneswar, in confiscation case number 4 of 2023. It appears from the record that during the pendency of the trial, the accused will expire. Therefore, the trial to delivery. Accordingly, the present appeal also stands debated by order date 15/7/2024. 2024. The LRs of the appellant, the deceased appellant, Kailash Chandra Rautraj, have moved the application 1977 of 2026, seeking setting aside of the abatement order dated 15/7/2024. They've also moved an application for substitution being IN number 1997 of 2026. Since the substitution application is delayed, how many days delay?
1790.
Delay. They have also moved an application. Well, which is that delay application is moved an application being IN number 1996 of 2023.
1987.
Condonation delay. What is the 198? What is this?
Is the delay application.
Last.
The IN number 1987 of 2026. They have filed. They have shown delay of
delay in filings. in filing the substitution application. Besides that, the applicants have also moved IN number 1998 of 2026, seeking conventional removing application for setting aside of abatement. Mr. Das, appearing for the vigilance, has filed objection to all the applications. The preliminary objection of Mr. Das is that the properties, when the confiscated properties are not belonging to the present applicants. Therefore, they have no right to prosecute. Apart from the said objection, there are many other objections taken by the Vigilance Council in their objection. The objections are taken on. I have carefully considered the submission. I have carefully considered the contention raised in the application, objection filed by the Vigilance Council, and I've also taken into consideration the rival submission of the parties. I'm satisfied that the applicants have a right to prosecute the appeal. Once they prosecute the appeal, which has been novated on the demise of the sole appeal, being the alas of the deceased appeal. Therefore, all the applications are allowed. The applicants are substituted as appellants in the present appeal. The counsel for the applicants will file one party, but let the appeal next follow. Let the appeal be included in the weekly list for final list for that. Yes, I've included in the weekly list for final list for that.
Interim order may be responding also.
There is no application for interim.
6/1/2017.
Huh?
6/1 on restoration. 1977/46 I number.
I set aside the abatement, whatever the consequences are there. It restore back.
Allowed all the applications.
All the application I will allow. Yes. Yes,
41.
41, my lord, jail conduct I have already solved.
Yes. What happened?
Custody certificate.
Custody certificate and
So you got it. These are bail, huh?
My lord.
Okay. 5 years.
8 years.
8 years.
8 years something.
20.
8
What-
years, 2 months something.
Out
What
of
is the
10
sentence?
years. 10 years.
10 years.
What do you say? 8 years, 2 months, 24 days.
10-year punishment.
This appeal is up for 2021. Right on. Petitioner,
given
the
Criminal
Excellent.
antecedents of Dilip Mokhal also have
Huh?
given. Criminal antecedents also have given.
criminal antecedents are there.
Of Dilip Mokhal.
Okay.
No criminal antecedents.
No criminal antecedents.
Not involved in any.
Yes, ma'am.
Why are you saying? 8 years. I don't know. Appellant 10 years sentence, huh? Appellant has been convicted. For offense the charges under section so and so and sentenced to undergo RI for 10 years and pay fine up rupees 1 lakh.
1 lakh.
1 lakh.
1 lakh. It was state realization of the fine has been state. Huh? There is no order. Has it been stayed or not?
No.
I don't know. I'll not say anything. When the appeal is pending since 2021. 21. On 29/7/2026, this court directed the State Council to obtain the custody certificate, criminal intelligence, and jail conduct of both. Pursuant to the said order, the jail superintendent so has filed a custody certificate as well as the conduct certificate, jail conduct certificate. As per the custody certificate, the appellant has already undergone 8. No remission. Remission is not counted as actual sentence of 8 years, 2 months, and 24 days without remission. The jail conduct of the appellants is found to be satisfactory. The IAC Orkil PS has also placed on record a report dated 14/8/2026 indicating that the appellant is not involved in any other case except the present one. The State Council, on the basis of the aforementioned report, the Council appeal for the appellant submits that the appeal is of year to 2021. There is no scope of the appeal being heard within near future. Hence, the appellant has already undergone major part of the sentence, Hence, the sentence is so imposed by the trial court be kept in suspension animation during pendency of field equivalent. The State Council has opposed the merits by drawing the attention of the court on the merits of the case. At this stage, I am not inclined to enter into merits of the case. However, regarding it to the period of custody and the fact that the appeal may not be heard in the near future, I am inclined to yes.
File amount already stayed.
File amount stayed, my lord. Fine amount already stayed on 2/4/24.
Yes, I'm not seeing that. Yes.
I mean, there are two appeal, my lord.
And what about the other one? This is Dilip. Only Dilip?
Both are
Same.
my lord.
Padmanavan.
Padman Kawasi also came.
Where is Dilip?
Dilip is 513. 514.
No, where is Dilip's this thing?
Dilip,
Only this is Padmanavan.
No, all are.
I have given all.
All are there.
It's only Padmanavan for custody certificate. Where is the custody certificate of Dilip? You have given only Padmanavan.
Padman Kawasi, Haridurga and Padman
Haridurga
Madkavi.
and
Padman Madkavi.
Padman Kawas.
Hey, where is the custody certificate? Give it. Why are you keeping it? Padmanavan read according. Very good. Take another record. Padmanavan. This is Dilip.
Dilip
Mahakal. Dilip
Mahakal, Haridurga and Padman Kawas.
Padman Madkavi. 4 जन.
Where is the period undergone?
8 year 2.
You counted it.
Yes, ma'am. 2900 and
29.
another is 2.
Converted to years.
Yes.
But Dilip Mahakal law and is ordered at 2/4/24.
Haridakwa. Where is Haridakwa?
Dilip Mahakal 2/4/24 mail and is order dated. IN number 931/24.
Dilip हो गया. Haridakwa.
Jail posted in 29/4/19.
The whole difficulty is none of you are rendering any assistance. That's the whole difficulty. Haridakwa, what is the period undergone?
8.
You calculate it, give it, at least this much you do it.
Yes, I have
Do you expect me to do all this thing?
No, I have calculated.
Second meter day after tomorrow. You first कर दियो इटा पद्मनो कर दियो and दिलीप वाला रखो more than 50. ठीक है? Calculate and give it. Yes.
My lord, appeal, 514 is
Day after tomorrow. Padmano Kawasi granted bail and whatever the other appeal, that is Dilip Mokhal and yes. Next.
42. Please, my lord.
Yes.
Here, my lord, the appellant is languishing in jail custody since, my lord, that is 3/1/2018, more than 8 years. And in absence of any aggravated penetration, he has been convicted.
Where from I'll get it the period of custody?
Though custody certificate is not with me,
Right on.
but he has not been granted bail.
Custody certificate from the jail conduct is the antecedent of the petitioner, lease the matter.
Sir, one connected appeal, that is 35, sir. Whereas the accused number 2, there is absolutely no allegation, but he is in custody.
Let us see the custody
Sir,
certificate.
sir.
Yes.
43.
43. 43.
27, 29 seconds. My lord, direct for issue notice to the informant.
What about this?
Report has not been received.
Sorry?
Report has not been received.
Right on. Pursuant to the order 29/7/2026. Although the notice was directed to serve notice to the informant of the victim is directed to serve through IIT Rajnagar, but no report has yet been received. Hence, the state council is seeking 1 week of at least the matter next week. Yes.
44.
Ten years and out of 10 years, 1 month had custody out of 20 years. And a 6 POXO along with a 376 2I of a punishment.
Okay. Notice to the informant of the victim to be served through the IHCs also. In the meantime, the custody certificate, jail conduct, and the resident of court petitioner be called for. Yes.
45.
May I please? In the last occasion, your directed.
Have you got the certificate?
Yes, ma'am. Prospect certificate.
Yes.
7 years, 3 months. Out of 10 years of conviction.
Ten-year sentence.
That is reflected in running page 22.
Yes.
Hospital certificate showing that 8 years,
8 years, 3
months.
28 days.
Minor.
Petitioner, the appellant is convicted under section so and so. POXO is there?
No.
No.
In the
What are the offenses?
Offense, the appellant faced trial for the offense under P76, P76 2N and 6 of the POSCO Act. He was acquitted from the other charges except 376 1 of the
Even notice was issued even.
judgment para 9 reflected.
Appellant is convicted for offense under section 7 and sentenced to 10 years of arrest. And pursuant to the order dated 29/7/2026, the jail superintendent, so and so. Which jail superintendent is this?
Jail superintendent, Baripata.
Which jail? Nothing is visible.
Baripata.
Baripata Circle Jail has placed on record a custody certificate which indicates the appellant has undergone actual sentence of 8 years, 3 months, and 20 days without remission out of the 10 years sentence. The jail conduct is also stated to be satisfactory. The IIC Vaishaninga PS has also filed a report dated 2/8/2026 indicating that except the present case, it is not involved in any other case. The State Council opposed the bail of the merits of the case. However, without entering into the merits of the case, the regards being yet to be period for custody and the fact that to be appealed may not be heard in the near future, I am inclined to suspend the sentence told by the trial court against the appellant. Accordingly, the appellant is granted the
Violation of fine money. Violation of.
stay release. Yes. Let us come there. Forty?
46.
46.
46.
There are 46 in appeal also. In this case, there are 3 connected appeals arising out of same judgment.
Yes.
So in this case, out of
Their interim bail is allowed on 21/5/26.
surrender certificate already filed, my lord.
21/5/26 ରେ interim bail allow ହେଇଥିଲା.
Out of 12 years of conviction, my lord, around already 6 months, 6 years inside custody. Basing on that ground, interim bail for 2 months was granted for all these 3 appellant hearing. And duly they have surrendered, my lord. The surrender certificate, my lord, is annexed and it is in the noting, my lord.
Yeah.
12 ବର୍ଷରୁ 6 ବର୍ଷ already undergone, my lord.
Would be the certificate, huh? It is contended by the letter counsel for the petition appellant that regarding the period of custody of 6 years out of 12 years, the ordinary bench of this court had granted interim bail for 3 months, huh?
2 months.
It was 2 months. By the order dated 21/5/26.
My lord.
26. Persons thereto, the appellants have already surrendered and surrender certificate is has already been placed on record. Let the state council obtain the purchase certificate to bail conduct and the antecedent of course the appellant for the popular contribution for application for the grant of bail and for application for suspension of sentence and the bail. Release the matter up on 7th of September. Get the custody certificate, jail conduct, and
On the last occasion, all these things were taken into consideration, my lord, and subsequent on the very day when the bail order was, interim bail order was passed, your lordship, on that very day, they have already completed 6 years. And they are.
Let the jail conduct and antecedent be that is the standard practice. It is only half of the sentence.
Half of the sentence.
Yes.
Sir. And generally, in NDPS cases, your lordship knows 10 years is the conviction, but hearing 12 years has been imposed.
And 32B or 34B has not been complied. Yes.
But make it paper short date.
7th.
7th of
7th September. Yes. Yes. Next.
47.
47.
47 sentence is 20 years for the under section 376D. And this petitioner is in custody since 30th 11/2015.
All in custody for half a sentence.
More than half.
10 years
Get
custody.
the certificate.
10 years, 6 months.
Custody certificate. You are appearing for whom? You are appearing for whom?
I'm appearing for appellant number 2. The person to prisoner petition, I filed Wakalatna. That noting is there.
Okay.
I am for Praveen Bala.
Get the certificate. Get certificate. Commission notice to be imposed to IAS. And release it on 20 year sentence.
20 years.
2 years out of 20 years.
Yes, in custody, about 11 years.
DC terminator, 21st September. Yes, sir. Yes,
48 custody certificate, jail
Yes.
conduct.
48.
Pardon, my lord. Convicted under section 341, 323, 325.
Have you got it?
This one is the corporate certificate notice.
The order dated 5/8/2026.
Arrested on
Right?
5/5/21.
For the state seeks to move with them to compliance. Let him also release the matter on 21st of September. Yes. Next.
49.
Convicted under section 6 of POCSO Act.
In this case, with the POCSO Act is there.
6 of POCSO Act and
Notice one of the offenses POCSO issue notice. In the meantime, the custody certificate, jail conduct, and the petition be also called for. Yes.
50.
50, my lord, I'm appealing for the sub-item 3 and 4. Madam Naidu is appealing for the first list. He's coming just another.
Pass over. Let her come pass over. Huh? Yes.
There are
one
custody certificate.
Not received. In item
50.
item 50.
Custody certificate.
Person to the order dated. No, it was not called for.
Not conduct, so that in a call first, then is going to consume.
Confused and please it up your check your issue. Yes. Yes.
51.
51.
51, madam, is here.
Yes.
For bail matter.
Yes.
The appeal was admitted and the insurer has also been confirmed that the appellant is convicted on section 419, 420, 465, 467, 468, 170, 471, 120B of IPC, that is section 66 and 66C and D of IT Act. The maximum punishment that the trial court imposed, that is in 467, 10 years. And
Yes.
1 rupees fine. In almost all the offences, my lord, that sentences have been imposed. And here the appellant is in custody since, my lord, 9/10/11/2022. 3 years. 9/11/2022.
No. You Binay Bhardwaj, na?
Vijay Bhardwaj.
12/11/2022 to 25/1/2024, when the judgment was passed, and after judgment also you are in custody.
Yes, sir. Since the point of arrest, I am in custody.
12/11/2022.
12/11, that the trial court judgment says that I was arrested on 9/11.
But no. Just see the first front page.
Judgment at 25/1.
Front page. Yes. Front page it says 12/11/2022. You have not been granted interim bail anytime?
No interim bail is granted.
So if you calculate from 12/11/2022, it is about
It's come to 3 years, 9 months.
jail conduct.
Jail conduct of that.
Your conduct and antecedent. Yes.
53.
53.
Here the appellant was convicted under 372 and 6 POCSO Act, and sentence is 20 years, and he is custody near
Notice was issued?
My lord?
This issued on 48/5.
Already appeared.
Somebody has
Already appeared. Yes, you are appearing. Who is appearing?
No.
Who is appearing? Custody certificate and all?
Yes, ma'am.
No. Okay.
Outline.
Yes.
54.
Offense 20B2C NDPS Act.
Sorry?
20B2C of NDPS Act. 10 years
10 years.
imprisonment, and he is custody since 11/7
jail conduct. Yes. Let it come. Yes, next. 50.
55.
Okay. Yes.
56. We appeal before your lordship. Offense under NDPS Act, 10 years conviction. The first appellant is a lady, my lord. They are in custody, my lord, all about 3.5.
300. Okay. Get the certificate. Yes. Yes, next.
57.
Yes.
307, 326, 10 years in the sentence. Previously, custody certificate was called for. It's on record. My earlier application disposed of with a observation that after its hearing did not take place within 6 months, I will renew my prayer. Now
Where is that?
1 year has passed.
Where is that order?
That order is order dated 13/8/25.
38.
25.
DC 8. 13/8/20.
2 years, 4 months I am in custody.
Okay.
No criminal antecedent.
Because of granting liberty to petitioner to move a place with
Accurate.
it is there.
Flag G.
Flag G. G4.
Because it's
Yes.
30 days, but till now it is 1 year, 1 month.
1 year, 6 months, 30 days. As in 2025.
Fine.
Now 1 year is
25.
added.
Huh?
Now 1 year is added.
Yeah, right. So,
And 4 weeks I have been granted interim bail on 12/12/25
yes.
as my mother died. That has to be excluded. So virtually 2.5
Yes,
years.
what is on merits? Let us see.
Merit Miller's
Who is the victim?
PW5.
Let us see.
He says
The name is you are
that there was a previous dispute. I was in rent. They drove me out. For that reason, while he was standing and purchasing vegetable and others are there, I came with 2 bombs and threw at him. He raised his hand and exploded. The bomb exploded in his hand. And the second bomb is also exploded. No injury nowhere to anybody, including himself. He suffered an injury on the palm only. Judgment Miller's para 12.
Then who is the doctor? Who is the doctor?
Dr. Miller's peculiarly, the medical college doctor has not been examined. The PSC doctor has been examined.
Who is the doctor?
PW4, my lordship.
4.
It has been summarized in the judgment.
No, see, the evidence is already there.
Yes.
It's a grievous injury, my lordship.
Yes.
See lacerated injury on the left
Fracture of metacarpal of the palm.
profuse
Injury is Exhibit 9
even
and
first aid,
injury
treatment
reports
and
Exhibit 19.
duration.
It's grievous because there is fracture of metacarpal.
So, the injury I found may be possible by vehicular accident. Prepare injury reports also. The palm injury.
Palm injury.
What is your antecedents?
No antecedents.
I will call for jail conduct.
Already there, Miller's.
Jail conduct and antecedent.
It's already probably there on the.
No, only the custody certificate is there. Custody certificate is already there on record. However, the jail conduct and the antecedent of the permit accused is not on record. Hence, the State Council is directed to obtain jail conduct and the antecedents, criminal antecedents of the appellant. Lease the matter on 21st of September.
My lord, may record my appearance. I have filed memo.
Mr. Studding's name, your name is reflecting?
No, I am appearing on
name.
the. I have filed a memo.
Reflect from the cause list. Yes. 58.
The petitioner was arrested on 6/1/2023.
What is the offense? Offense.
20B Roman 2C. I've been convicted
Sentence,
by the learned court below.
Sentence 10 years.
10 years.
10 years.
Sentence 10 years. Okay.
The appeal memo is not with me, ma'am.
It's a jail criminal appeal.
But appeal memo is not with me.
I also don't have. It's a jail criminal appeal.
Okay. Call for the custody certificate, jail conduct and antecedent. Let us see. Yes.
Last order, your lordship may kindly see.
Let it come first.
Appeal was admitted. Order dated is 16/1/2025.
Yes, it is admitted. Trial court record is already there.
Yes.
Let us see the conduct. Yes.
59. Your lordship is posting.
I'll give a date.
59 may I please, my lords. My lords, on the
My
last,
bail is to be considered.
59 my lords, on the last occasion, notice was issued to the informant, my lords.
Yes, notice just see.
No, my lordship. Not my lordship.
Huh?
No, my lordship.
No means
The order is there, but not issued.
not issued.
Not
Why?
sufficient.
Service, you don't have the report or you have not?
Because appeal memo was not with me. Today I
Lord's extra copy was
send the letter to the concerned IAC.
What are the offenses?
My lord, POCSO Act, 6 of POCSO is there. Out of 20 years, 10 years, he has already, my lords, been incarcerated.
It has been admitted and registry supplies soft scan copy of so.
Fine has not been
Extra
checked.
copy. By order dated 2/7/26, though the appeal was admitted and notice was issued to the informant oblique the victim. But service report is not has not yet been placed on record. Let the state council take the first step to serve the informant oblique the victim through the IIC. Which police station? IIC so and file the service report. Sorry, police station you tell.
Joda.
Joda police station.
Yes, next.
60 custody certificate and
And in the meantime,
and conduct
the
certificate.
conduct as well as the indigent we also summon. Yes.
Conduct certificate also, my lord.
So give it a yes, 60.
60 grateful.
Yeah, Lord. With the chief mother, sentenced for 20 years for the offense under section 376 AB reduced section 6 of POCSO. Custody since my lord 10/9/2018, near about 8 years. And
Sorry? Undergone.
Yes. Because then the custody certificate is there. It was showing that 4859 30 years. So,
Out of 20 years.
yes,
yes. That's 376 AB. It's POCSO is there.
13 years, 312 days.
Then my lordship, till date, my lordship, it was showing.
What have you written? 13 years, 312 days plus 7 months.
Plus 7 months, my lordship, it was still 25, I think.
About 14 years. Yeah?
Yes, my lordship. It was 14 years. Fine.
Was there any direction to bring? No. Has been convicted for offense under section also. And as the has been sentenced to undergo so. The appeal has been admitted by the order dated 13/1/2026. What is the name of the appellant is Jawaharlal Sukarma. The state council has placed on record the custody certificate issued by the district jail superintendent Jharsuguda. The report indicates that the appellant has already served out the sentence of about 14 years, 5 months. 14 years, 5 months out of the total sentence of 20 years. The appeal is pending before this court since 2024. The new scope of the appeal will be heard on this. It's subsequently taken in view of the substantive period of substances the appeal has already undergone. Since the appeal is not likely to be heard in the near future, I'm inclined to suspend the sentence pending the appeal. Accordingly, the appellant shall be released on bail on forms of funds. Yes.
61.
Yes.
Since 19/4/2024, RI for 20 years under section
Yes.
of POCSO. Conviction based on evidence of
Amicus is ready? Yes. Yes.
Conviction based on evidence of Pedule 5 and Pedule 9. Pedule 5 is
What is the period custody undergone?
custody since 19/4/2024.
About 2 years. Roughly about
2 years, 3 months.
Yes.
Both are belong to one village. Victim as well as
Show me the victims.
PW 5.
PW?
PW 5.
PW5, yes. PW5.
5 statements.
Let us see. I was in class 9, so
Basically cross examination.
At about the school closed, I went to
Last 4 lines.
Kolhapur bus stand to fetch the bus to my village. At the time, accused Vishal came to me and requested me to go with him in spite of my denial. He forcibly took my motorcycle and kept in his sister's house also, where the sister did not allow me to stay in their house. Thereafter, we moved to bus stand. The police him and he kept me in a room. He kept me with me. On the next day morning, the mother of the accused is there and who stayed with us. The accused left the place without informing on the public. If you brought me to the station, police station. Yes. Who is the doctor? No. Cross examination we want to throw.
Para 6 last 4 lines. Para 6.
Yes. We walked for 20 minutes to reach the bus stop, and that's what you are saying?
Yes.
In
From
between
the house of the sister accused, in between 11:30 to 12 noon, we reached at the bus stop, from where we went to the Puri on the pretext of marriage. Oh, that's right. What is the age of
and you'll also kindly see the PW9.
age? What is the age?
PW9.
Huh?
14 years.
14
That
years.
is nowhere.
Yes. PW9. Who is PW9?
Doctor.
Doctor, what does the... There is no sign and symptom of intercourse within 48 hours. When she was examined, 18/4/24. When the incident taken place?
15.
Okay, after 3 days. She is not habitual of sexual intercourse, no bodily injury is registered, no event present, no physical. Yes. Yes, madam.
On 15th, she was kidnapped. On 16th, she was with the kidnapper. On 17th, 16th evening or somewhere there, the mother of the kidnapper reached. As per the doctor, he's saying 48 hours. That cannot be ruled out because that is, if we count, that is on 15/4/26 evening it may be. So no one can be ruled out that there is no sexual offense. And the age has never been stated that she is...
What is the age of this boy?
14.
Huh?
14 years.
1/4.
And they have never objected to anywhere. No exhibit is there marked with the objections. So the age is confirmed. Regarding 164 statement also, she has stated that what has happened. If you go through that also, it is on 15th. And the doctor also says that 48 hours earlier, she is not habituated to sexual intercourse. There is no sign and symptoms of sexual intercourse within 48 hours, but sexual intercourse cannot be denied.
When does I'm not verify the document regarding the identity of the victim and so on. So as there is no injury on her body, it is suggested that
And on
it
18th,
has not been forcibly sexually assaulted. It is not a fact that the examining victim maybe forcibly, but the consent is neither here nor there.
Doing the appeal, alert will merit. I am on bail. Here, Mala, since Mala found that both are belong to one village.
How will you get out of POCSO? Yes. Sentence.
So at the time of concession bail, Mala knows the position of law.
That's the problem.
Since Mala is in custody since 2024. More than
Let us see his
and that aspect will also one vital aspect.
Yes.
While during medical examination, before the doctor, she has stated no sexual harassment at all. It is admissible under section 35 of the
Where
Evidence Act.
does he say? Where does he say? The doctor doesn't say that.
Your
Doctor
Lordship,
found it.
No. Your Lordship, can
Where does the doctor say that the girl is
Exhibit 6. Mala.
Exhibit 6? Let us
Yes,
see.
that is there. Exhibit 6 is the medical report is there.
also even if it is on consent also, consent of a 14-year girl can also taken into the and on a pretext that he is going to marry him.
2 days. Rather, whatever she says may be correct from Exhibit 6. 15/4/2025, 25 whatever. And
Yes.
she said 2 days. After 2 days, she has been examined.
On 18th, she was examined.
Recovered by the mother, petitioner's mother herself.
See, Exhibit 6, whatever you say, is contrary. Just see. As per the victim,
Yes.
just see. He take him and forcibly for puri
Do not.
and do nothing.
Do nothing.
Do nothing.
That is there. It is admissible under section 35. Smaller state defense has conducted the case. Man Lord knows. Once state defense has conducted the case, this
And
matter is there.
when the 164 statement was recorded?
164
On
statement.
18th.
18. What time?
19th April.
19th is recorded.
19th.
And 18th she tells the doctor nothing has happened. On 19th 164 she gives a different story. See the exhibit 6.
Yes, ma'am.
Exhibit 6. Exhibit 6 strengthens the evidence of PW9.
As per the victim, he takes into him forcefully.
So conduct. Although jail conduct, custody certificate, jail conduct, and indictment. Least the matter on 7th. 7th. I think. Let us see whether he is involved in any other case or not.
All.
7th. Madam, difficult for you.
A little bit.
Yeah.
There is the
Let's see.
process to me.
Just find out if it's anything. Because see, doctor says that there is no recent sexual.
So doctor says something different. They
But see, this is on 18th when he writes, he generally interact. And cross-examination is after so many days, you know. And that is his own version. And the version of the girl is being reflected in the exhibit itself. On the next day, 164, she says something else. Yes.
62. My lord, may kindly see the order dated 7/8/2026. My friend was.
Yes, ma'am.
Your service?
Yes.
Service is there?
I have received the
Show me.
appellant has been, the informant has been died.
What about victim?
Yes. The notice and also the mother of the accused, my lordship, is not well. That report is also there. They filed an IE.
Interim bail I've
Right
had.
to engage the interim bail.
Interim bail.
Madam, pursuant to the order dated 7/8/2026, a report has been placed on the court. As per the report, the informant in the informant is the mother of the victim.
Mother of the victim.
Mother of the victim. Informant, the mother of the victim has already expired. However, the notice has been served to. Where is that notice served to?
My lordship. Number.
Served to whom?
My lordship, the receipt from the.
The victim.
Yes.
Where is it? Where is the signature?
So order is a sign कर दीजिए.
Hmm?
Order itself is a sign कर दीजिए.
Notice has been served to the victim. Victim on 14/8/2026, but none has entered appearance on her behalf. Therefore, so is appointed a university to assess the court. Assess the court. In the interim application, what does it say?
But I filed the IA that the mother requests medical treatment.
And in the first page it was written, the mother of the appellant health condition.
Mother of the appellant, health
Yes.
condition is seriously lumbar radiculopathy as per the opinion. The report of IIC dated 15/8/2026. IIC Ottawa, dated 15/8/2026 also reveals that the mother of the appellant is suffering from lumbar radiculopathy, and her condition is serious. And it is also reported that the medical document attached to the bail application also genuine. And genuine, there is no male person in the family to look after the mother of the appellant. matter to the appellant. The reports are taken on record since none is appeared for the victim. So and so is the point taken in the history. Release the matter on today 17th. Release the matter on 21st. 21st. Make history for 40. After here. 21st of this month. Yes.
Interim.
Interim for interim bail only. Somebody has to appear as a MAC history. I have recorded everything and that day I'll give. Somebody should formally appear.
Yes.
Yes.
63.
Yes. 20 of
I'm sorry. Section 376(3) IPC and that is section 6 of the POCSO Act. The sentence into 20 years arrival.
notice.
Yes, they have appeared.
They have appeared. File the objection. Of the file. Yes, objection is also there.
Objection by the state, my lordship.
State objection.
State objection. is-
Yes. What about the objection? Who is appearing?
Deepak Kumar.
Deepak Kumar sir.
Deepak Kumar sir.
The custody certificate is also, of course, not there.
Okay, custody certificate. So pursuant to the order dated 16/4/2025, so Deepak Kumar, what is Deepak Kumar? Sahu. Generated appearance on behalf of the victim of the informant. However, no objection has been filed as yet. The state has already filed objection to the bail prayer of the appellant. Let the state council obtain the custody certificate, jail conduct, and indication of the appellant. Release the matter on 16th of September. Yes.
64.
Lordship, the appellant is convicted under section 6(1) of POCSO for
Notice-
20 years.
Notice issued.
Lordship, I have solved the requisite. But in the
Written answer.
Your Lordship, address is out of station, Your Lordship.
So
Let-
IAC let the victim informant be heard through IAC. The attempt made by the appellant to serve the victim has will pay in view of pain, which will reflect what is the report?
Addressee out of session.
Addressee out of station. Total remark, addressee out of station. Release in the meantime, the custody certificate and antecedent from shall also be summoned. Yes.
65.
Today I pray for consideration of my bail application matter. So I am convicted under POCSO Act 4 and 6 along with the other provision 363, 376 and
The notice has been issued.
yes, notice has been issued already.
Who is appearing?
Nobody appears.
Service.
Notice has been-
Despite
My lord,
service of
this is the
notice. I have to appoint someone. Service of notice on the victim of informant. None has had appearance. Therefore, so has been appointed history to assess the court. Release the matter on. In the meantime, custody certificate and jail conduct as well as the indication of petitioner be also called for. Called for. Release the matter on. Now, what is the sentence?
20 years.
20 years. How much you have undergone?
I am already in custody for more than 3 years.
3 years.
Fourth year.
Release the matter. I will give a date. I'll give a date. I'll give a date. Yes. No.
66.
Yes.
There was a delay.
Sorry?
There was a delay, my lord.
It's not yet admitted.
No, my lord.
No.
Yes.
That's the word.
Delay of delay 177. Delay in filing the plea against the judgment so and so. Delay of 177 days. Stands condoned for the reasons stated in the application. Admit, call for the trial court record. What are the applications? There is no application.
1068.
What is the offense?
Offense, my lord, 376A B, my lord.
Six POCSO is there also.
EC notice and through IC. Please the matter on. Yes.
67.
My lord, I filed the IMI lord for interim application lord, sir.
For what?
Interim bail my lord.
Interim application?
Yes, 2038 of.
What is the ground?
Ground mother is my lord. Fertilized lord, sir.
I number 2038 of 2026. This is an application seeking interim bail on the ground that the mother of the appellant is seriously ill. He has also filed certain documents, medical document in support of the application. The same shall be verified and a report be filed by the next date of hearing. Release the matter, release the interim bail application on 11th of September. Yes.
Your lordship, in this case,
11th September.
I open and
I only I.
I.
Yes. 67.
67, may I take question? On the strength of prisoner petition, I entered my appearance.
Yes.
The,
You filed the Vokalatnama?
my lord, already filed.
Yes.
So 67 is a, I think it's a matter of OPID.
It's a matter of paid.
Open then OPID counsel is there. So thankful notice as well.
In the last occasion, there is a order, my lord. Both the counsels, for the appellant and the respondent, they received the soft copy from the section, my lord.
OPD counsel, his name is reflecting?
No.
Huh?
No.
The OPD counsel's name will reflect for this. And what is the sentence?
Is the offenses 420 along with other offenses. Highest punishment is 7 years. Out of 7 years, he is custody since his date of arrest, my lord. Since 2 years, he is in custody.
Okay, custody certificate, jail conduct and antecedent. That's allowed to be summoned by immediate appearing. Release the matter on 18th of September. Yes. Supply the copy to OPA. Yes.
My lord, in the last occasion, there is an order, my lord. They received the soft copy from the sections, my lord. Because I am strength of prisoner petition appearing.
But you inform the OPA.
Inform.
Yes. Yes, next.
68. Lordship, in the meantime, CA report also recalled.
Yes, yes, I have called for.
CA and
called for. Yes.
Conduct.
68. 68 mallet, two appeals there, mallet. First is mallet, the both husband and wife they convicted and sentenced wife mallet first applicant 459. She is sentenced to 7 years and 4 mallet only 366 34 17 of the POCSO for abatement. And
what about the
7 year sentence, he was on bail.
1 minute service.
Service of notice was there in our last order, my lord.
Non-appeared.
Non-appearance.
Despite service of notice on the informant of the victim, non-agented appearance. Hence, so is appointed as MIK to assist the court.
That had been ordered, my lord, earlier date.
MIK has been appointed.
No, that one more opportunity, that is notice is sufficient.
Yes.
Despite of that, no one is appearing.
I am appointed MIK to assist the court. And what is the period undergone according to you?
I was on bail.
What is the period undergone?
Already I was on bail during trial. That is one running page 11 of.
Then I'll call for a custody certificate, jail conduct as well as the antecedents. Please the matter for hearing. Yes.
69. 7 years after 2 years more I am in custody with lady.
I'm calling for the report. Let the report come.
Custody certificate is in the.
That's right, but nobody is appearing. I'll have to appoint someone. I have already appointed someone. I'll hear this objection. Insofar as that lady is concerned. Lady is concerned.
Lady is concerned, that is ML because he was convicted on 366.
I know, I understand it.
And for husband, I'm not at.
What do you want? I passed the order. Why are you waiting? Let somebody appear for the. Yes.
69.
You have decided to speak a couple of sentences, you will speak. Even if it is not required. So wait, why do you waste time?
Eager for the lady mallet because
I know, but
20 years later.
I know, but I have to hear someone. I have to appoint someone. Yes, I have appointed already. Yes.
69.
Yes, 69.
And is the CCL man. At the time of incident, he was 16 years old.
What is the offense? What is the offense?
Offense matter POCSO.
Yes, notice.
My lord, I am appearing for the victim.
Yes.
Till date also, he is my lord in the observation home at Raukala. Custody my lord 25/9/2022.
Yes.
The age of the
victim. Custody certificate and jail conduct as well as antecedent. And I'll hear it on On 18th September. Yes.
Case one, the case is at Fulwani, but now the appellant is in the observation of Rourkela. State Council may obtain from the Rourkela.
Raurkela, from Raurkela observation. Yes.
Observation.
Yes.
70.
Conversation is among the oversight matter. And other than
What about notice? Notice.
2.5 years custody and sentence.
Notice to go is
Notice has not been issued.
No.
Notice. The notice issued through IIC so and so police station. Which police station? Police station. Konasa police station. In the meantime, custody certificate, jail conduct, and the antecedent of the appellant we also called for. Yes.
71.
Pardon, my lord, IA number 3306 for interim mail, that may be not present.
Not press. IA number 3306.
06.
Not press. Yes.
71.
If it will load in 71 in criminal appeal number 1071 of 2024. I am in custody for more than.
It is a NCB matter. Mr. Ponda is there. There is a instruction from the
This is
superintendent
NCB
of
matter.
Yes, my lords.
NCB.
So far as the first sub-item is concerned, my lords, we have obtained the custody certificate. But in the second sub-item, it is yet to.
You get it.
My lords.
The second sub-item.
As well as your my lords.
And what are the antecedent? Because these are NCB.
We'll take.
Antecedent is very important. for
We'll
paying.
take specific instructions with regard to antecedent.
Jail conduct. Lease the matter. What is the period? 20 years.
10 years. 10 years.
How much you have undergone the first matter?
They have already undergone more than 5 years. That's
5 years. Then get it there.
More than 6 years, my lord. Date of arrest, my lord.
30th September.
May I place the depositions copy as well as appeal memo be served to the.
Oh no,
union.
already TCR is there. Soft copy of the TCR being made available to the council, respective councils. Yes. Yes.
That's both the items.
Both the items.
72.
Item 72, I'm appearing through VC.
At item
Yes.
72, I may kindly be permitted to withdraw my power since the above named appellant by the prisoner's petition wants to engage my senior appealing on this. I don't know.
Let
The
council,
names of
council
Pradeep Mahatan's
has moved and we move to withdraw the power in view of withdraw the power changing the law. The prisoners have petition dated 28/26 received. As per the prisoner's petition, the victim or the appellant seeks to appoint CORAM, the council. The Vokalatna file.
Yes, Your Lordship. The prisoner petition contains them.
Names will be clear to be called this in case of Pradeep Mahapatra. Yes, yes, Mr. Saurabh.
Page 66, my lord. My lord, the notice has already been sufficient. The informant chooses not to appear.
Despite service of notice on the informant of victim, none has entered appearance, and therefore so and so the appointed as a magistrate to assist the court, least the matter. Custody certificate has already been summoned.
No, my lord.
In the meantime, custody certificate, jail conduct, and as well as the antecedent of the appellant we called for. Least the matter. What is the sentence undergone by you?
My lord, less than 2 years, but please have page 66 for a moment, my lord. Just one. The cross-examination of the victim, my lord. Only page 60.
I'll hear it. Okay, no
My
problem.
lord, she has entirely resigned. She categorically states that nothing has happened and still I'm convicted, my lord. My lord, love affair between both of them, 22 years old guy, today 23.
Okay.
So can it be next week, your lordships?
Not next week, not possible. Next week, on 9th of September.
My lord, can it be any day prior to that, my lord?
No question. 9th September. No question. 9th September only, yes.
Great.
Yes.
73.
May I please answer? The appellant has been convicted under section 354A and 354B, my lord. 4 year sentence, my lord. Out of 4 years, my lord, 17th month in already, my lord, undergone, my lord. Lordship kind of have a glance to the victim statement. What kind of allegation against the petitioner, my lord? That paragraph number 2, that is the victim statement, my lords.
24, no?
Lords. PW2.
Yes.
Notice जाइतला notice रे
PW
2, my lord. That is the victim, my lord. Paragraph 2. The incident happened about 7 to 8 months back. At the time of such incident, at about 10 a.m., I was sitting on a culvert in my village. The accused told me to give his water bottle to his hand. Then the accused called me inside his house. Thereafter, the accused, my brother, this is the allegation. Nothing else, my lord. Say,
not to get him to neg me and so on so.
Setting allegation. आप किसी नहीं मिला? आप 4 वर्ष कौन 70 वर्ष already gone.
Yes, what do you say, madam?
Chief,
Medical, any
no.
doctor examined?
My lord?
Any doctor examined? Yeah.
No, my lord, that is doctor examined.
Yes. The victim is a 10-year-old girl, your lordship, and her statement is consistent in 164, 161, your lordship. Yes.
Oh, you are 35 years.
Yes, now he is 35.
10-year girl.
जा घर ହେଇଥିଲା independent witness, he has not supported the case, my lord. PW.
But he, in 161, he is
PW3, my lord. PW3 with the independent witness, my lord, to the occurrence, my lord. से कुछ आरी घर ହେଇଥିଲା, से कुछ ମୋ घर ହେଇଛି, ମୋ ପାଖରେ ଯେ ମୁଁ ଜାଣିନି.
PW3, who is PW1?
PW
Mother.
Mother.
Incident happened to my daughter.
The very same day the affair was filed in your lordship, and he stated at the same time after our mother came to home.
The neighbor. During the time of the accused called the victim on the whole cycle, and thereafter the accused took the victim girl inside the house and found on the victim right to house and the victim wanted to ride to the house and told me about the thing. But see, PW1, if you see, she gives a different story. During that time, the accused called the victim girl to hold his cycle. Where is that? That story is not there.
Your lordship, but she is the 10-year-old girl, your lordship. As per the POCSO section.
No, she was saying that she was sitting in a culvert.
Yes, your lordship. She
only says that I was sitting in a culvert and asked for a bottle of water.
Corroborating, your lordship. Other statement, what?
Other whose statement is called?
The assault, your lordship, the sexual assault.
How? Whose evidence is corroborating with this?
Your lordship,
Nobody has seen his house. Thereafter, the accused, the accused took, the accused told me to give water bottle, and then the accused called me inside the house. Whose house is this?
My lord, that is PW3, my lord.
PW3.
PW3, my lord. So victim calls in the paragraph 4, lordship can have a victim paragraph 4, my lord. So paragraph 4 victim called, I have only told to my mother about the incident, but not other. The house of Lakshmi Sahu, PW3, my lord, and the accused are close to that culvert. The PW3 statement also can have a glance. Where, my lord? I do not know anything about this case. I was not also examined by the police.
But the
cross-exam declined. Cross-exam.
Yes.
17 मासर
period of custody, where from I'll get it?
My lord?
Period of custody, where from I'll get it?
PW3.
Custody period.
A period of custody, my lord. 17th month of our calculation, my lord. Date of arrest.
Call for the report. Call for the report. All the 3 reports. List it on 9th September.
My lord.
9th September. I'm getting a report. Your contact also. We are 35 years old. Let me see the contact.
Notice gala, my lord. Notice रे appear कॉल है victim, my lord. तापर यो लॉर्डशिप डायरेक्शन लीगल एड आसी अपन डायरेक्शन कला पर हमर एप्लीकेशन
नेक्स्ट
74
में
yes
may I be please this is a 6 popcorn and a 20 years conviction.
What about the service?
When now in the meantime what happened, my lord, victim and informant already appear. This and also present today, and they have filed before this honorable court the affidavit. This affidavit is in the flag C and flag D, my lord. they have not any objection for the.
They may not have objection. That's it.
For that development is I'm saying, and they have also interested to marry each other. For that is the reason, and also is it custody. And it is a consensual relation. They have relation, and for marriage helani boli, that is the cause, and that is the consistent statement. Just
show me the statement.
Okay.
Yes.
P1 is the P1 is the victim.
Yes. What is the age? What is the age? 18 years. Oh, 20. Yeah. Further, after 1 month of
attention, the cross-examination para 13
minutes video and having physical relations with me when I registered in the further attempt to physical relations with me, the accused threatened me and so on. So the accused uploaded the video or physical relation on the Instagram, and then said video was made viral. And you have not only done this, and you've taken the video and
that is that is not IT Act is not that
where does it say that?
Yes, I am confirming. Para 13 on that statement cross-examination can be drawn.
1 year prior to the
It is a fact that 1 and prior to the incident, I and the accused were in the love relation.
Yes, what do you say? They have filed affidavit that they would be getting married.
Affidavit is a fact.
Where does it say that the flag C where you have they
flag C for informant and flag D.
Where is the girl?
Flag C is the victim.
Where is
informant?
The girl and mother is there.
Yes.
And
both parties also present.
So Mrs. Marana, Sarita Marana is there. Sarita is there. Sarita Marana. Interact and tell me. Okay. Pass over. Please interact and tell me. Yes. Okay. Yes. Next.
75.
After lunch.
No. After lunch. Immediately after lunch. She will interact with them. Let her just understand whether you have obtained it forcefully or whatever. She will interact. Yes.
My lord, in this your lordship call for a report regarding custody.
Yes. Report is there.
Conducted.
We go to the report. What's the offense?
376D, man. 376D is the sole accused. 376D.
And the informed, the victim.
My lord.
Only custody certificate is there.
Only custody?
Yes, ma'am.
4 years, 10 months. 9 days. Pursuant to the order dated.
4 years, 13 days at the time of.
Yes, received from the Superintendent Circle Jail, Cuttack, Chodwa. Dated 28/7/2026, which indicates that the appellant has undergone about 4 years, 4 years, 10 days, 4 years, 10 months, and 9 days in custody. Yes.
No, Lord.
Which is taken under account. Yes.
No, Lord. In this case, the initially FR registered under 342, 376 and
who is the victim?
Victim is PW1.
PW1. Yes.
And in this case, the conjunction, the case, as per the police report, the 5-6-21, but the statement of the victim is that it's 5-7-21. And that is the statement of IO is 5-6. But the victim says that the 5-7, the date of occurrence. My lord, in this case, the IO admitted that there is a lot of action between parties. In the statement of
read the prosecutory statement. Let us see. We are not arguing the appeal.
No.
Read the prosecutory evidence.
The PW1 is the victim. The statement of victim that one Ganesha called him to the house and closed the door. The present appellant committed
This is on 11/9/21. Oh, that is after 2 months.
After 3
Yeah,
months.
what do you say?
That is after 3 months.
My lord, he has filed a IO for interim bail and interim bail press koribo na main bail.
See, interim already over. Men
Na interim bail would okay jota.
No. Interim already over. And on that occasion, on the expert, he went to dispersal.
Yes.
It is over.
Yes.
My lord, in PW1, madam. PW1. The first para.
Yes.
And the last line, my lord. She has categorically stated that, my lord. The accused Rakesh Behra is the present appellant, my lord. Committed forcibly sexual intercourse with the even after.
With
Yes, read it.
I was, my lord, relevant person I was reading, my lord.
Read it.
Yes.
Who stops you? Read it.
I was going to give a book to my friend. On the way, near the house of Anam Das, the accused, another accused, my lord. Ganeshwar Sethi. My lord, in Ganeshwar Sethi case, my lord, his trial is going on, my lord.
Going on.
Yes, my lord. It told me that your Didi, sister, namely Sima, is calling you. Then I went to the house of Anam Das and found Sima Didi was not absent. Sima Didi was, for which I was about to leave the house. But the accused Ganeshwar Sethi dragged me to the upstairs of the house of the accused Anam Das. There I found accused Rakesh Behra was present. Rakesh Behra is the present appellant. Then immediately accused Ganeshwar Sethi closed the door from the outside, my lord.
Yes.
Then accused Rakesh Behra committed and forcible sexual intercourse with me. Even after, my lord. Even after their own. My protest. Even after my protest.
Yes.
Then I knocked the door, but nobody opened the door. After about 2 hours, accused Ganeshwar Sethi opened the door from outside. That means the door was locked from outside, my lord. Immediately I returned to our house. At that time, my mother was absent in our house. So out of shame, I did not disclose the incident to my father on 8/7/2021. While I was going to my tuition on the way, accused Ganeshwar Sethi told me that he, along with Rakesh Behra, have made my nude videos and threatened me if the material will be disclosed to anybody, then they will upload my nude videos in social media and kill my parents. Thereafter, 2 days again, while I was...
There are direct evidence.
My lord, on that aspect, I could for that. And in terms of the police highway and the occurrence took place. Herself and on 2 days after further call to her, I admitted that it is a fact that PW1 victim has stated before me that while she was
Where are you reading? Who is the IO?
IO
PW7 doctor.
PW5 IO.
Yes.
Right. It is a fact that PW1 has stated before me that while she was prosecuting her study, she had courtship with the accused Rakesh Behra and they used to talk with each other over phone. There is a law relationship. Only there are no medical, the medical evidence.
Whatever IO says is not more important. The prosecutor says clearly.
My lord, prosecuting. My lord, he is inside jail custody since last 5 years.
RI for 20 years.
My lord, on a 376 he is the sole accused. The lower
Ganeshwar is also an accused.
Ganeshwar is not by only the other.
He's pleaded. He's facing the trial.
My the evidence of the prosecutor is Ganeshwar not committing any sexual assault. Ganeshwar only Ganeshwar.
Take
Ganeshwar.
October 1st week. We'll see. Let 5 years be complete. Let 5 years be complete. Yes. First week. 70 कितना Yes.
My lord, one more thing, my lord. My lord, I may be provided the soft copy of the
Soft
TPR.
copy, yeah. The then counsel for the
TCR.
informant. Seek to the soft copy, same is allowed. Yes.
76.
Yes.
Petitioner is convicted under section 8 of the POCSO Act. The conviction period
What about
3 years, your lordship.
1 minute notice.
If not, sir.
Issue notice.
Issue not issued.
Issue notice. Issue notice. Also through IN. Yes.
77.
Yes. 77.
Here the conviction under section 376, 366.
Yes.
376 to N. For 10 years,
Notice,
366 and concurrently. The accused was in custody already for more than.
Notice to the victim of the informant, and in the meantime, the custody certificate, jail, the NT be also called for. Yes. Next.
78.
78. You filed the requisite late.
My lord, late will be fixed.
Late will be fixed. Don't worry.
Second item.
Yes.
I was granted interim bail.
But POCSO is there. POCSO. But
surrender certificate is there.
Okay, I'll take the second item, right? Pursuant to the NP granted by this court on when the interim bail was granted.
Interim bail was granted sometimes before vacation, my lord, for 1 month.
Out of the on 13/5/2022, the appellant has already surrendered. Surrender certificate. Surrender certificate which is taken into court. So far as the other matters are concerned, requisites, all of you filed the requisites late, so therefore the service could not be affected. So therefore service could not.
Application for interim bail is pending. Your lordship has called for report from the state council.
Yes.
On the ground of illness of my mother.
Yes. Have you got a report in the second item?
Lord, I am appearing for the informant in all the cases.
He is already appearing. Yes, already appearing. Yes. Service is not required. In second item, have you got the reports?
The reports, my lord, the notice has been served.
Already further notice.
No, my lord. No, it's the illness of my mother.
Pursuant to
father is suffering, my mother is suffering.
Pursuant to the order dated 7/8/2026, the state council has not stopped in instruction regarding the status regarding the health status of the mother of the appellant, and he seeks 1 week time. 1 week time. Let him obtain the instructions by next date of hearing. Release the matter on 7th of September. Yes. 7 September.
I thought that
you'll get it. How much time will you take? Health issue
is shifted to 1 week first. At least 1 week. Next Monday, you will see.
24th. You get that report. At least the mother is suffering. Yes. Yes.
3/8 of 2026. Copy has not been served on the appeal.
Normally admit in appeal.
Admit in.
Because Mr. Malvikar appeal admitted our serial number 4 so only after admission you can give copies.
Admit all the appeal. Admit all the also in there, na? So no notice is required to be issued to.
My friend has already entered appearance for the.
No notice is required. I'm admitting and call for trial court record. Since trial court
pay realization of fine, bail will you consider that?
Since trial court record has already been called in the CRLA number 285 of 2026, no further record in that case, and the realization of fines state in all the cases. All the cases.
My lord, I'm appearing in sub item 1, my lord, CRLA 287. My lord, I have filed an interim application for the surgery of my father. That was sent for verification. My lord. IA number 1824 of 26.
Appeal number
287 of
287.
26.
IA number
1824 of 26.
1824. This is an application for grant of interim bail on the ground that the father of the
Father, surgery of my father.
father of the appellant is what have you said?
My lord,
Uh,
backbone surgery is to undergo.
Surgery. Therefore, the interim bail for a period of how much you are asking?
3 months, my lord.
Interim bail for 3 months paid for. Along with the application, certain medical documents were also annexed. Let the state council obtain instructions regarding the authenticity of the medical document by next date appearing. And 24, both the matters. 24. Yes.
CRLA 338 of 2026. 338 of 2026.
Yes.
There are two appellants. I have filed interim application in respect of appellant number 1. People also see the medical report.
Ground?
Heart failure. My father was admitted in the hospital.
Father. IA number 2016.
Yes. 2016. IA number 2016.
It is criminal appeal number 338. 2016. This is an application for interim bail filed by the appellant on the ground that his father has a serious medical issues. He has filed certain medical document to substantiate his submission, which needs to be verified by the state council and file a report by next date appearing. Lease the matter on 24th, all the three interim applications. Okay. Yes.
79.
29 Miller. Sir, your lordship directed me to file. Here I am not an accused, Miller. I am not an accused, the present appellant. He filed the petition against the order of Miller, the trial court in rejecting a petition for release of a vehicle. The vehicle relates to her, Miller, and her husband has been convicted. Here, Miller, I have to file the judgment copy, lordship directed, so I pray 1 week time, and in the meantime, Miller, 14-day delay may be kindly condoned.
See on that day, the accountable petition seeks an adjournment. Release the matter on 23rd of September. Yes. Next.
80. Committee may proceed.
Yes.
My lordship, I am pressing the IA number 2005/126 for bail.
What's the offense?
My lordship, petitioner earlier was released on interim bail 36/126, and surrender certificate has been filed on order annexure 1. My lordship, obtains under section 294, 323, 326, 506, 34 IPC. My lordship, each convict is sentenced to undergo 5 years and rigorous imprisonment and to pay fine 10.
What is this interim order? Bail application?
My lordship,
on what ground?
My lordship, is application for bail.
Regular bail.
He was earlier, date of custody since 17/3/2026.
You said interim bail application has been moved.
In that application, I have filed the bail. The lordship has granted me interim bail for a 30 days period of.
You surrender already.
I have filed surrender certificate.
Talk about the regular bail application.
Now, my lordship, I am file for IA for 2005 or 26 for bail. My lordship, the injury is simple in nature.
Custody certificate, jail conduct from the antecedent we summoned for. Release the application on 23rd of September. Let this custody certificate and jail conduct as well as your antecedent be called for.
Yes, my
23rd of September.
Here today or
What is the offense?
offense under ESI Act, non-payment of contribution. Law will tell you that the report, except the report of witness PW 2 to 4, no other document was filed by the prosecution. But he consider Exhibit 13.
Against acquittal. Against acquittal. Okay, we'll take it up.
Item 36.
Keep it when the matter will be taken up, you give it and let me run through the list first.
Item 19. Report has just now received the report and adjournment died.
90. From the same order. First, Mr. Gordon, so report from the report dated 16/8/2026. Proceed from IIC and from police station. Who is the appellant?
Appellant number 1 is Antaram Padi.
Antaram Padi. The sole appellant has died in the year 2006 in the absence of any applications moved by the deceased appellant. And so, abated. Yes.
I seek your indulgence to mention item 37 in the second list. Item
Yes.
37, this is the matter which I had mentioned last week. This is the appeal which hearing from my side was completed.
Vigilance case.
Yes, that matter. And
Vigilance.
indicated that
Yes.
these matters would be taken up in a bunch on a particular day so that the Vigilance Council.
Mr. Das, just see 37. Mr. Das, just 37. It is part and matter, in fact.
In fact, my appeal was completed.
There are corrected appeal insofar as Mr. Rizvi appeared, it seems. Insofar as his appeal is concerned, it appears to be heard completely.
Only his, there are 3 connected matters, my lord. As so far as his appeal is concerned, it was heard. The next 2 appeals are yet to be heard by your lordships.
Yes.
And that was heard before Honorable Mr. Justice C.R. Das.
No, before your lordship also it was heard.
Then
Thereafter it went to Justice C.R. Das. There also it was heard. Again, because of this.
What is happening to the other are appealing there? Other appeal.
They are the ones who are not cooperating, for which at one point of time, your lordship had appointed amicus.
If they are not coming, you will appoint amicus. We can't, wait for it. Take it up. Take it up.
Today,
Can
will it be taken up today?
Let us see. I will finish it up with my board first. Then I may take it up. Yes.
I'll be there. I'll be there.
Personal item 32.
Yes.
You heard the petition. Challenge the order passed by the trial court, rejecting my application not to frame charge. Application filed under section 239.
Yes.
Background of the case is
19 to 26.
well,
Yes.
and instead of deciding the point which I have raised, when trial court was pleased to dispose of the application, it's a stage of charge. I cannot go for mini trial, this, that. It's not a question of mini trial. I'm not saying that. Well, case was registered against petitioner under LMC page 14.
Yes.
For the offences under section 13(2), 13(1)(a) and 409.
Yes.
The case prosecution is that petitioner was entrusted with 7,40,000
Yes.
to disburse the same as old age pension. Though he had distributed 4,53,800 to the beneficiaries, and he did not distribute rest 2,86,000 to the office immediately. Well, this is the case of the year April 2018. But petitioner, when found that the money has been left out, he returned the same on 18/12/2019.
Yes.
Well, you got it?
The FIR is registered on
FIR is registered on
27/8/2020.
My lord,
27/8/2020. Basis of
on 18/12/2019.
On the basis of a complaint filed on 28/7/20.
FIR was registered for the offences of 27/8/2020.
Yes.
For offences of 13/2 read with 13/1A/409.
Come to page 16. What are the allegations? See?
Right.
Yes.
That is the allegation, madam.
27/8.
They say 2,86,000 has been misappropriated. But let me see page 17. Last two, 3 lines. It is proved that Sri Maharana, ex-PEO, kept the government money of rupees 2,86,200 with him from 30/6/2017 to 20/12/2019. With an intention to misappropriate the government cash.
Before that, if you come to page 16, last paragraph, during inquiry, it came to the limelight that
Subhash Chandra Maharana, ex-PEO's other plot, Estate Palestine, in his tenure during year 2016-17, has received advance of rupees 2,60,000 in cash on 12/8/2016 from Southern Block for disbursement of the old age pension for the month of July 2016 on Olonda Sargaon GP under Southern Block District Malaysia by voucher number so and so. Again, Maharana received rupees 2,80,000 in cash on 15/9/2016 from Southern Block for disbursement of the old age pension for the month of 2016. And so in total manner, it's around 7 lakhs. That is very detailed. But the fact that money was returned prior to the lodging of the information.
No, 17, the top paragraph, the third line. He disbursed so and so to the above month of so and so to the beneficiary out of so and so,
In total 7 lakhs.
and returned the acquaintances loan towards the disbursement of
16/17. He did not deposit.
He did not deposit the undisbursed amount of so and so for last 3 years. 3 years, and he has relieved from so and so on 17.
But the fact that before the affair was lost, he had deposited. I'm coming to that. That is the point. I'm not going to the.
But the fact remains that 2,80,000 rupees will
First question is
remain undisbursed, remained with you for 3 years. Even after demitting office, you have not deposited.
First question is whether a case can be registered for the Prevention of Corruption Act as well under Indian Penal Code. First question. That has been answered by 2011 SCC.
That's 409 interception. Yes.
So, Hon'Ble Apex Court was pleased to observe the case in 1991 1394.
Yes.
Like this one. 91?
Yes, which para?
Procedural first. Allegation of purging bills and misappropriation law, thereby committing criminal breach of trust. Sale of credit, so and so. Stored in official capacity. Prosecution says of purging bills and receipts and using them as genuine, not held. Amounts alleged to have been misappropriated proved to be deposited by accused before emission. Charge under 409 could not be sustained.
Relevant paragraph.
Relevant paragraph is 28, 26, 27, 28, 30.
Read it. Continue.
It's facts paragraph. This point has been taken note of. This Supreme Court judgment has been taken note of in 2011 SCC online.
Now, what is the ratio here? Does it say that by the time the amount is deposited, before the FIR is registered, the charge under 409 is not made out? Is that the ratio?
The ratio that has been the decision, whether the amounts alleged to have been misappropriated proved to be deposited by accused
That's a placitum, but placitum, you know who writes.
Well,
Read the judgment.
It's was wrong. Right. But this analogy has been more detailed explained in 2011 SCC online, the record 1209. There, but these two both points have been taken note of very in detail. Here, it's a case of trial, but the Supreme Court judgment. The Allahabad High Court judgment has been reversed.
Here the facts are different.
Here,
it is overlapping charges between two appellants. So
here the
who was interested?
It can be distributed in two ways. It's a
There
case
the court says that in the first appellant.
When I first this judgment, whether it has been relied in the subsequent cases, this has been taken note of till 2004. On the point that even if concurrent finding of fact, court can take note of it. In relying upon this Narendra Pratap Narayan Singh versus State of UP, 21 Supreme Court 1394.
This on facts of this case, this may not be applicable.
This has been taken note of in 2011. 11 SCC online, Jharkhand 1209. That's all. Somehow, I have the printout. 2011 SCC online.
What is the ratio? What is the ratio?
Ratio, both the things have been taken note of. I've got in.
What is the ratio? What is the ratio?
That if the money has been deposited before investigation, relying upon 91 Supreme Court, case has been closed.
And 409.
Well, here there also section 5 as well.
409. Get those judgments. Okay, I'll place you. Fix it on 28th. 28th.
No, I have got other materials with me. So far judgment is concerned, even temporary misappropriation also is good enough.
Yes.
But I have notified the judgment.
But the fact is, for 3 years you retain the money.
Not only that, it's not so simple, my lord. I can put in other words, last 3 years, downtrodden people, they are deprived of that.
That's right, you are right. You are right.
Yes,
there was no reason for him to retain the money.
Collector used to go to different places to
when he might have got the feelers that there will be a case, immediately went and joined.
They were deprived of their basic things.
Yes. Right. Yes. Next. 33. Non-appeals in the interception October. Yes. 33 is which years? 1 years. Okay. October. Yes.
74.
Lordship, I have talked to the victim. She wants to marry the accused, my lordship. And that found the bail can be granted. On that found the bail.
Similar like another court member taking that set aside.
No, that part.
That I do.
No, that is different thing. Because here medical.
Let us.
But here medical examination has already proved. But that is different.
We'll see. That time we'll see.
And the
petitioner, to begin with, I'll give 3 months interim bail. Let us see. Petitioner, the appellant has been convicted. And sentenced to undergo so. And you remain in custody for how many days?
Before trial, 10 months. Now after conviction, 20.
No, during
2025.
During trial, you remain in custody for 2 months, 27 days.
10. Thereafter, the Honorable Court release on
Just see the impugn order, impugn judgment.
After judgment, you can grant for date.
Impugned judgment, just see, during the trial, you remain for 2 months, 27 days. Why do you say 10 months?
Before trial.
That is what I'm saying, before trial only. You don't read the file and come.
Because
What because?
he's arrested on.
Just see the trial court judgment. In the judgment, it is written.
Yes, yes.
So then, 2 months, 27 days. Means what? Why are you making a wrong statement? I don't understand. During the trial, the appellant has undergone 2 months, 27 days custody, and after judgment passed on 29/11/2025, the appellant is in custody. Is in custody. The appellant is facing for suspension of sentence pending appeal. The victim as well as the informant, which is mother of the victim, have filed a separate affidavit before this court inter stating that the victim is stating that the victim is interested to marry the convicted appellant. The convicted appellant is also ready and willing to marry her. The mother of the informant, mother of the victim, also have filed affidavit stating that she doesn't have any objection for grant of bail. Take into consideration the development which is taken in view of the affidavit filed by the victim and the informant. The appellant is granted 3 months time, 3 months interim bail, 3 months interim bail, from the date of the so 3 months I am granting, let us see. Yes.
Stay of filing.
Stay of admit, it has already been admitted. Okay, stay the yes.
81.
May please.
Acquittal.
Order of acquittal under challenge.
You are the informant, huh?
Yes.
The informant informant has filed the present appeal against the judgment of acquittal. Judgment of acquittal dated 23/7/2025 passed by the JMFC in Potamundai in GR case number 510 of 2010. Issue notice to the opposite party number 2, the opposite party number 228. The requisites to be filed in the yes. File the requisites. Yes.
82.
Stay of order of
You are going to copy the stay of person.
So next week.
No, you may kindly have a glance to.
I'm rejecting it.
It will be added in the hearing list in its individual.
This is an application.
Appeal of the year 2026.
Seeking stay of the conviction, impure conviction dated so. I'm not inclined to entertain this application at this stage. However, the appeal is
of the year
directed to
26.
Included in the weekly news to be heard. Course, yes.
Maybe hearing.
Hearing I have added. No question of stay of conviction. Yes, next.
83.
29/5/26.
Correction has been given. Correction. Your lordship may kindly have a glance to dated order dated 29.
Which one? Which item? That is over.
This item.
That is over. Next item.
83.
That is over.
Then delay of 2 months and
delay in filing appeal of 111 days stands cancelled. Actually stands condoned and appeal admitted. What is the offense?
POCSO.
Yes. Yes, next.
And delay.
Next.
POCSO notice.
84. Delay of 47 days in filing the appeal. Stands condoned. Appeal admitted. Issue notice. Yes.
85.
Minor 7 PC Act conviction 4 years.
85 last order may kindly be perused. It has already been admitted. LCR has been called for. Stay of fine has been made. And the copy was to be served. I have received the copy. 7 PC Act. Your Lordship's discretion is in custody since the date of judgment. He is in It is your Lordship's discretion.
Another stay of conviction.
Stay of conviction I object.
Stay of conviction. Which is the A? Which is that I?
57.
IA number
1958 stop conviction.
1957 of 2026. The application is rejected. In 1958, right of the appellant has been convicted and sentenced to undergo arrive for 4 years, and he is in custody since 37 for the regarding to the nature of evidence and period of case also granted bail. Yes, realization out application of realization stay. Yes, next. Yes.
86.
Bail granted and that application is rejected. Conviction rejected.
Another document.
No. To press for that, then I'll not pass any order in bail application. Decided. Yes.
86.
Yes.
The order of conviction without previous association 498 and 34. Appellant is the married sister-in-law. 3 years conviction. Fine of rupees 20,000.
3 years.
3 years.
What is the name? Name is Promila Viswal.
When the entire position of the law. Junior is 3%.
Yes. 389 benefit was not granted to you.
All through you
You are in custody since?
no custody. Page 17 years kind.
No. 17.
The in-law, that's is in the trial period, he has not been.
During trial, she was on bail, but now after the impugned judgment, you are in custody or? Since last 1 month you are in custody.
No. 1 month period. After this.
389 3 benefit was granted. That's what I'm asking.
Yes.
Okay. The petitioner, the appellant has been convicted for offense under section also and sentenced to undergo arrive 3 months. The appellant is the sister-in-law of the informant.
Deceased.
Deceased. During the trial, the appellant was granted bail. However, after conviction, the trial court has granted the benefit of section 389(3) and granted suspended the sentence for 1 month to appeal filed regarding here to nature of evidence and the fact that the appeals cannot be heard in the near future. I'm inclined to suspend the sentence pending appeal. I could only grant bail. Yes, next.
Stay relation.
Stay relation. Yes.
87.
Whatever passed by the female mass, the 227 application has been dismissed. That by the female act, under the CBI go on, is Bhubaneswar under the female act. Here is one of the 702 days delay for filing this one of the criminal register.
What is the stage of trial?
The charge has been framed now.
Thereafter evidence.
The charge has not been framed. So if the charge has been framed, then my application will be charge has not been framed. Okay, here I am filing the 27 petition. The application has been rejected.
That has been rejected. You approach this court after about delay.
But till date charge has not been framed.
Are you where are you? How from where from you got that? Objection. Let us see the objection. There is no stay. There is no stay.
It's not condemned. So that is not an admission. 702 days delay.
700.
702 days.
And still the charge has not been framed.
Lordship, while the proof was initiated by the vigilance pillar, the 11 witnesses have been examined. Till that, nobody has been examined till now. And 2 female cases has been filed. So on the ground of
where is the question of examining witness? Charge has not been framed according to you. How many accused are there?
So Melody, 2 accused. Husband and wife.
Is there any stay that instance?
No.
Yes.
Now, the best this matter. The 2 female proceeding has been instituted in this proceeding, in this case.
It's all right. Why have you came?
I am filing that there is a double jeopardy because the 1 female case has been registered.
But why so much of delay?
I am filing another female case that is the attachment proceedings there.
That has nothing to do with this.
Before the appellate authority. So I am waiting for the said proceeding, but the attachment authority after the passing order.
So how? What is the relationship between those 2 proceedings?
So because the 2 two people the proceeding was introduced. Kindly for a moment.
Show me your application for conviction.
Yes.
What was the reason you have said?
Regarding the charge melody in para 4, we have stated that charge has been framed in my objection.
It was not within frame.
So in para 4.
When charge
objection, yes. Now in para 4 of my objection.
Yes.
I have said that it is also submitted that.
You have not read the objection.
No, I have read it, but charge has not been framed.
Then if he says charge has been framed specific, you should have verified it.
Last occasion, they are submitting that submission. They are instructed that charge has not been framed.
File an affidavit. Charge has not been framed. Because you are making a very specific statement whereas they have also filed an affidavit saying the charge has been framed. Either you are making a false statement.
The charge has been framed, then my entire application will be enforced.
So therefore, receipt 4 of their objection.
They have filed objection.
Has already.
They have stated below the 19/7/2023
advanced stage where the charge has already been framed and the next date of hearing is April 2026. By now, witnesses have already been examined.
Pending of charge.
Okay, file an affidavit. File it. Mr. A.N. Patnaik seeks an adjournment to file an affidavit disclosing the exact status of the trial. Release the matter in the on 18th of September. Yes. 18th September. Next.
88.
Yes.
Your Lordship, my Lord. This pertains to, my Lords, in a trap case, my Lord, the accused was let off courts. And the state has preferred this petition seeking leave of this on court appeal. My Lord, in this case, my Lords, basically the acquittal order because of the accompanying witness turned hostile. What I suggest, my Lord, this is a case of 2012 minutes. I have given the list to the earlier bench with Justice Mahapatra to dispose of many matters now. I have also prepared some of the left cases of I will be adding a few more now. If all these matters.
All are acquittal. All acquittal.
Yes, but there is no urgency now. The state has preferred this.
No, there is urgency. These are unnecessary piling up.
Correct. I am on that point. My lord, I'm coming back to your lordship. My lords, I prepared a list of 2012 appeals, my lord, gathering dust, my lords. My lord,
All are against acquittal?
against acquittal, my lords. I think one day it also can dispose.
Yes.
I'll give the entire list.
give.
Another two
Mr. Das appearing for the submit that similar nature of cases. How many cases you have?
List.
1 minute.
Extra. So I'll be giving this to
A couple of similar nature of cases.
2012.
It's been filed by the Vigilance Department against the acquittal judgments, and he submits that all the acquittal judgments and all these appeals be listed on one
Leave petition.
leave petitions listed in the leave petitions. Be listed on this. List it on.
So, they are acquitted, absolutely, they are scot free.
Actually, apply because of pending this.
You have been acquitted already.
Only my initiation was old cases be disposed.
No,
I said that is a top case.
On 10th of September. 10th September. All the give the list, Mr. Das, to supply the 10th.
Then I started his own leave with this one. It is absolutely a state petition only seeking leave. Leave has not been granted.
Leave will be declined, then everything goes.
They are free, they can go to any.
Next.
He knows not he.
You have been acquitted. How it is creating impediment?
No stumbling.
Leave has also not granted.
Only my full cases be disposed. That's why I give the list.
Give the list, Mr. Das, to supply the list of the cases. All the cases you give, one day we will dispose of.
Yes,
Yes.
The also meant that the pendants of this case have not been barred.
Ask something which is not required at all. Yes.
Case has not been admitted.
Next.
Granted plus.
89. Yes.
I don't insist on nothing because of this. Insist
Yes. Sorry? What are you challenging?
Here we are challenging that the whole total proceeding before the consumer forum is not written everywhere. Because there is no relationship and that is what the CDA alleges. Because we have not allotted any plot at all. Application was rejected with the threshold. That is one part. First part is that whether Honorable High Court, because there is a national forum, that is what minus expressed. Honorable High Court can interfere in such a case or not. Minus two. I took time and insisted on Friday, not taken out.
Yes.
One decision directly minus and family. That is of Chhattisgarh High Court taking note of all.
Delhi High Court judgment you see.
Delhi High Court. I have done note Chhattisgarh High Court. Delhi High Court decision has not come out, but that the decision I think if I would agree that this here in this case, minus can be.
Delhi High Court judgment is other contrary to what you are saying.
I have not gone that far.
Delhi High Court judgment is that. What does it say?
Because
Which para?
paragraph doesn't look at. Paragraph 23. This is a case my husband also in brief.
Para 23.
In brief, may I some. What happened in that case? That is the coal mining transport. The transportation agreement was there. There was a residue. Then they have gone with the person concerned to get that amount. Where we come from. Then the honorable, the control from the honorable court by the state of in this case, no. The contingency doesn't die and it is not a consumer cannot be interpreted. That is what honorable by paragraph 23.
It's the lack of jurisdiction.
This is my case. Lack of jurisdiction. Here in this case, what happened, my lord? Thing is that first one is to get admitted, one is to certify that the consumer. In this case, what happened?
Whether he is a consumer or not, the consumer dispute court will decide.
Exactly. That consumer forum said, didn't deal with that, but we raised that point that it's not maintainable before the forum. Because we have not allotted any plot at all. That plot was never allotted. He has applied for.
Why can't you? The question is, why can't you tell all these things to the national consumer? Because it is far away from you. And it is nearer to your house. High Court is nearer to, that's the ground, basically. High Court is nearer to you. So I'll not go to, there is a statute. And these are the creation of the statute. The tribunal is the national forum is a creation of statute. And if you are agreed,
That is that matter. This case have come that.
let us see what the
Coming within 3 exceptions. That is what I.
no. Let us see what the district forum says.
District Forum said that didn't discuss about that. We consider that we raised that point. We consider that they said that he applied in application form. But fortune is that mere application in the application form.
What state forum says?
State forum, they also didn't disclose all these things.
There are two words.
We discussed. We raised that point. Now the only option left.
I'll keep it open and you.
Then my lord, I need permission to.
I don't say anything and simply you say that at the outset you are withdrawing, keeping all the questions open. And no, I'll give you liberty. I'll give you liberty. The present petition, in the present writ petition, the petitioner is assailing the order dated. Which order you are challenging? Order dated?
Order number 3. So also order under Annex 3 is also.
Right. Order dated
11
consumer forum, order dated 11/2/2014 passed by District Consumer Redressal Forum Cuttack in CC case number 208 of 2011. And where is the State Commission order? And the order dated. And the order dated. Where is the order? Order dated 17th March 2023 passed by no.
But it's state forum.
State forum. District forum will clarify. State consumer dispute resolution in first appeal number 114 of 2014. Since an alternate remedy under section 20 under section
51
of Consumer Dispute Consumer Dispute Act 1985 is available to the petitioner to assail the impugned orders before the National Consumer Dispute Resolution Commission. The liberty interested to resort to the remedy, resort to the statutory remedy available to the petitioner. It is made clear that this court is not expressing an opinion in the minutes of the case. All the contention, right and contention raised by the parties before this court in this present petition is shall remain open to be urged by them before the National Consumer Dispute Redressal Commission. This observation, the writ petition is disposed of. Yes.
Execution proceeding that is going on. Year number 3823.
Since subject to the petitioner filing the appeal before National Consumer Dispute Commission within 1 month, the execution proceeding. Where is the execution proceeding?
88 to 93 under Annex 7.
Annex 7. Execution proceeding pending before the Dispute Redressal Commission, District Consumer Dispute Redressal Commission, Sector 1, CDA, Bidanasi, Cuttack, in the file of execution application 30 of 2023, shall remain state. It is open for the petitioner to move appropriate application before the National Consumer Dispute Commission seeking stay of the execution proceeding. Execution proceeding, it is expected that the National Commission shall deal with such application as expeditiously as possible. Yeah. Annex 6 or 7? Impugn order.
6.
Annexure 6.
And 6,
The
impugned orders.
the impugned, the certified copy of the certified copy of the impugned orders on the records may be returned to, can be returned to the counsel for the petitioner by replacing a photocopy of the same. Yes. Yes.
Item 90. Here. And challenging the order passed by the Divisional Court in National Consumers Forum. That is at page. It starts from page 27. The ground of challenge before your lordship.
Direction to be given to the court set aside the order dated 9/7/24. 9/7/24.
What your lordship is that it has been passed by a member who is a technical member. My lord, I have seen your lordship has given the hint that the rules have been amended. I have checked up the rules. Your lordship may kindly have asked for rules.
There are 2-3 judgments in this case.
Placard, I have given the note as well as all the judgments of the Hon'Ble Apex Court. And the recent judgment,
Yes, there are judgments.
Rajasthan High Court has delivered a
And even Delhi High Court has dealt with this issue.
Yes.
In para 19 of that judgment, I just I was reading para 19. The Delhi High Court deals with all these thing and says that if the judicial member passes an order, it is maintainable. But the technical member can't do it. Judicial member can do it.
Yes.
Only one thing I was about some. Rightly or wrongly, Lordship order has been passed by the National Commission, Your Lordship. The Lordship must see the first paragraph of the judgment. This is a judgment which has been passed in the original side of the National.
No, whatever it, if it is judicial member, it is sustainable. If it is technical member, it has to go. This simple.
But so far as the Supreme Court judgment, Your Lordships, there is a judgment. I'm referring because I have also filed the judgment. The judgment.
I'll set aside, remand it, and with a time bound, I'll do it. That's all. Why to get into?
Yes, Your Lord.
And if you go to Supreme Court, the same thing will happen. Better I'll do it so that you can, I'll set aside, remand, and
For limited purpose, since the judgment has been passed
by a technical member.
But I have brought this notification. He is a technical member.
Section 20.
Judicial, had it been judicial member, it could have been.
That's
the thing.
Rule. And the rule has been amended saying that even if it's a judicial member, even
Judicial member is maintained.
That's for Your Lordship.
Judicial member. Right. In the present petition, the petitioner is sealing the order dated 9/7/2024 passed by National Consumer Dispute Redressal Commission in CC number 58 of 2018. The sole ground of challenge to the order is that the impugned order is passed by a single member of the National Commission who is a technical member. In support of the argument and counsel for the petitioner has relied upon the judgment of the Honorable Supreme Court in NBCC India Private Limited versus Ranjit Singh Redu and others this is High Court, the Delhi High Court judgment. It's all right. Relied upon the judgment of the Honorable Supreme Court in HLV Limited versus New India Restaurants Company, civil appeal number 6569 of 2023. And in the judgment of the Honorable Supreme Court in state of Rajasthan and others versus Vasu Kamal versus Kamal Travels Kekas International, others in SLP C number 4969 of 2020. In both the matters, besides the judgment of the Supreme Court reported in 2023, 11 SEC 594, Fajan versus Omix Build Home Private Limited, Limited. Many judgments. And so on and so forth. So judgment would have in all those matters, the Honorable Supreme Court as well as the different other high courts have authoritatively held that a order, public judgment passed by the National Consumer Dispute Redressal Commission by a technical member is not sustainable under law. Yes, this judgment I was talking about. No, this sustainable. In view of the aforementioned, the only course left this court is to set aside the impugn order and remand back the matter to the National Commission. Agreely, the reproduction is allowed. The impugn order is so and so passed by so and so stands set aside, and the matter is remanded back to the NCDRC. NCDRC with the request to dispose of the 60 case number so and so as explicitly as possible, without expressing any opinion on the merits of the case. Yes.
May I pray one thing? My other friend's name we also record.
Yes. Record the name. Yes. Yes.
Professional point.
Yes. Next.
91. The 91, my lord, we should have more time because of that matter. There is the missing of that pistol. That FIR has lost, but we are not received the up-to-date report. That's why I pray of more time to next week.
What is this matter?
This matter was heard on the last day. What has happened in Lordship during election is not in predictable. It concerned IIC of my police jurisdiction, where I have the consigned 2 weapons to deposit the 2 weapons in order for public's.
Okay. The one is returned, the other one. Yes.
Yes, that from Malkana it is not found. That's a FIR investigation. So for the lapses in our part, I have called for the IAG concern to file a defector affidavit.
You have to give compensation.
Ultimately, that order will pass if they will fail to return. That next week, so we can file affidavit. Then
next week. Yes. Next week. Yes.
92.
Again.
I thought the WhatsApp because
Lord, I am appearing for opposite part number 1.
Yes.
in this case, all the last occasion, your lordship had directed me and your lordship will allow it to finally heard by the consumer commission on merit. But
what are you challenging?
Challenging the order passed by the consumer commission in rejecting my application for it has been dismissed for default. Thereafter, I filed a petition for restoration of that is review application, and it is number and review application that has been dismissed because that has been
you went to the state forum against the
consumer
district forum sort.
Yes,
okay.
Because it is dismissed for default, and thereafter.
Show me the default order.
Yes, ma'am.
Show me the default order. Yes.
Our default order is.
By which order it was dismissed?
Page 18.
Yes, 18. Non-appears for the appellant and.
Thereafter, RA has been filed in late.
502 days delay.
500
review, my lord.
Your lordship.
And then delay for condemnation after 272 days.
What is the dispute?
Dispute relating the petitioner has purchased the plot, my lord, on the auction purchase.
Plot. Yes, plot. Okay. Yes.
Compensation has been.
How much compensation? District forum order that. Let's see.
District forum has directed.
Which is the order?
Page 15.
15. Yes. What is the order?
My delivery of possession has been given. Everything has been given. Because it is an expedited order. Because objection has
been delivery.
What is the value of the property?
The value of the property he has given the amount The Lordship may see the sale certificate.
Hmm.
It is NSR 5, page 45.
Yes. What is the value?
8,15,000.
8,15,000.
Sale certificate, it has been, in the sale certificate, it has been stated that the possession has been handed over. My Lordship may see page 45.
So what remains then?
But for that reason, he has filed a case that possession. Now, sometimes what happened after giving the possession, the person, the owner of the pet, they created disturbance, and for that reason, the disturbance, there is a disturbance.
You have taken the position. What remains then? Huh?
Lordship may kindly come to the order of the district commission.
It is an expert order.
No. Kindly see annexure 5.
Yes,
I'll clarify, my lord. My lord may kindly come to the
Annexure?
district commission.
Yes. Para, which para? Yes.
That is para 14, page 14.
Yes.
My lord may kindly come to the issue number 1.
Mm-hmm. Yes.
Last 4 lines, my lord. Quorum on its own motion deputed one advocate commissioner with the
Page 14.
no, sir. With the consent of the counsel of both the parties for a field verification to excavate the reality with regards to the position of the said property.
Advocate Commissioner has visited the spot and with instruction to interrogate and form and so on so visited the spot and so on so. And what is the report? Clearly reveals that the fact that at no point of time the house in question has been vacated or not the delivery of position of the same.
Our advocate also.
But there is independent.
That was never challenged, man.
Commission was appointed.
But that is commission, your
Lordship may come to the last line of the order.
An expert order. No WS has been filed. In absence of the objection, that order has been passed.
No.
And it is
The advocate commission along with the counsels for both the parties.
Yes, ma'am. Thereafter.
You also went there.
And
Visited the spot.
the question has been vacated, nor any delivery of possession of the same has been made to the complainant, to which the advocate for the opposite party vehemently objected, which is in our view is not tenable.
That was never challenged.
Our view is here.
Then if your advocate was there with the commission, why have you not participated? How is this ex parte order?
It has been participated. In hearing, we have participated. But no WS has been filed within time. For
So
that reason, it is
casual.
an
I kindly come to the last.
Anyway,
apart from
I will give an opportunity. First appeal is right.
Just for a minute, kindly come to the last paragraph of the
One. Yes.
Kindly come to the last paragraph of the operative part order.
Yes.
In furtherance to the order of the opposite party bank,
The director to take necessary and proper action on the office concerned of the bank and who executed all the illegal act and after the proper inquiry and also opposite party bank want not to repeat the same so and so. All these things. And the only
it is a case of Prosecution Act. The appeal lies before the DRT under section 17.
But why have you not given the position?
Possession has been handed over. After the disturbance.
This is the observation made by the district commissioner.
But that is not correct. If at all we have filed the documents.
If it is not correct,
then section 14 and other remedies are also there.
Yes, ma'am. If at all that
has not been, never has been challenged, my
So why have you not gone in section 14 and all that? Those
we have given.
My lord, he is a poor villager.
Poor villager, all right. Okay, you paid 50,000 rupees. 50,000.
Some
No, 50,000.
50,000.
In
the meanwhile, my lord,
see cost of 50,000 rupees. Otherwise, this dispute will remain like this only. You are not going to get it.
It's better they the national commission, my lord. Just to 500 दिन आ गया 502 days they have delayed.
That delay is not condoned, so therefore I am condoning with a cost of 50,000 rupees to be paid to you. Yes. Then go to national commission. I will just withdraw and go to national commission. Give 50 or go to national commission. You will pay how much you know there, the lawyers. You know that.
I know very
Lawyer cost is less. So therefore give 50. The present petition has been filed. No, I'm just giving in direction. Challenging the order dated 12/12/2025 passed by the State Consumer Forum in review of number 17 of 2025, bracket annexure 4, as well as the order dated 28/10/2021 passed in first appeal number 78 of 2018, annexure 5. The respondent herein approached the District Consumer Forum by filing a consumer complaint case number 53 of 2015 by the order dated which is the order dated 18/8/11/2017. The consumer complaint was allowed with the following direction. That page 50 following direction. Agreed by the same, the petitioner bank approached the State Consumer Forum by filing first appeal number 78 of 2018. The said appeal was dismissed for non-prosecution at the counsel appearing for the petitioner did not participate in the proceeding. Against the said dismissal order dated 28/10/2021, a review petition was also prepared by the petitioner bank before the State Consumer Forum, being review petition number 17 of 2024. The review petition is to the review petition suffers a delay of how much? Was a delay of
500. My lord,
500.
2 days of delay.
500?
The condemnation petition was filed after 272 days of after 500.
Total delay you tell me.
502 days.
502 days. The State Consumer Forum rejected the application for condonation of delay, as a consequence of which the review petition also dismissed by the impugn order dated 12/12/2025. Against the same dismissal order, the presented petition is filed. Then counsel appearing from both the parties argued the matter at length, taken me to the documents placed before this court in this petition. Without waiting to the minutes of the case, I feel it appropriate to set aside the impugn order and restore the first appeal to the file of FA number 78 of 2018 before the State Consumer Dispute Redressal Commission, subject to the petitioner paying a cost of rupees 50,000 to the respondent, within a period of 1 month hence. Since first appeal being is a right of continuation of original proceeding, and it is statutory right of the petitioner. The appeal is restored. Appeal is restored, and since the the dispute pertains to the year 2016, the State Commission is requested to do it to see that the appeal is disposed of on its merit as expeditiously as possible. In this observation, the will stand out. Yes. Next.
Small clearness. With this matter, the first appeal may dispose
that I've said that. Yes.
Grateful.
50,000 you pay and respect questions.
I'll tell you.
93.
Yes.
If you have a glance.
Yes, notice 3.
July 2026. July 2026.
This your office note. There was a direction to the
I may submit my lord. One IA has been filed, that is 3/9/2026 to modification of that order.
Which order?
Your lordship's order dated 7/11/2021 arising out of which the contempt petition is filed. Why am I lost? 3 writ petition was filed. There are altogether 5 disciplinary proceeding was pending, not yet been decided. Nothing has been disclosed. 3 writs for 3 types of order he has obtained.
practicing fraud, your lordship make taken of the IA.
Yes.
That IA, your lordship, para 2,
yes,
annexure at page 17, B/2 annexure.
Yes.
That petition was filed, lordship kindly prayer. That prayer was to regularly service counting from stipendiary engineer period on completion of 5 years. That page at 32.
But why are you not filing in affidavit? Why are you moving in application?
Then we are moving now. We are preparing because of flood situation. The SE is in problem. Next week we will file this disclosing everything. When the second in that petition, second petition you make a glance. Second petition.
Yes.
Against which this contempt petition has been filed. That is at annex lordship. '59.
Why have you not challenged that order? The order
simple sitter that representation disposal. Representation consider and disposal. That order it has annexure 1.
No. The order by which he is aggrieved for non-compliance. If you see in the contempt petition, annexure 1, just see.
There will also
the writ petition number 31205 of 2025. This order was passed and there is a specific direction.
Yes. We have considered the representation and that disposal.
Where is the representation? It doesn't say about representation.
In previous writ petition other things.
Forget about previous.
There is a order I may submit. There is a order if there is no legal impediment. Since there are 5 divisional proceedings pending and he is not participating,
then why don't you file compliance affidavit saying that there is a legal impediment? It cannot be compliant.
That's why next week I have
the contempt.
That's why I file next week because
why this IA? I don't understand why. What is this IA?
Because to bring all those facts which a suppression has been made. For that,
I have already given a direction to the registry.
I never next week no so-called affidavit to file. Because of flood situation, the SI is in trouble. Next week will file.
I will not take cognizance of that. I am just asking the registry why this order is not compliant.
Next week.
Why this order is not compliant? 21/7/20. Yes. 21/7/26. Order not compliant with the registry. Who is the concern? Already scanned. Where is that? The registry was directed, last paragraph, registry was directed to issue notice of contempt, calling upon to explain why this is not issued. Who is section? Who is that? Call for explanation. Call for explanation. Call. And go, tell him to meet me. The registrar as well as the section of 4:30. I'm seeking an explanation from my registry people because there was a direction
that
on 21/7/26 for issuance of contempt notices.
Service option.
Yes, they have not done it. I'll just list it on 11th. 11th. Okay. 11th. And tell him to meet. It appears that the registry of this court has not complied the order dated 21/7/26. Last and final opportunity is given to the registry to comply in the same. Release the matter on 11th. That official order for you of the all of them to. Yes. Along with the file. Yes.
94.
Okay.
This case, the petitioner is challenging Annexure 1, which is the order of cognizance that was taken by the learned trial court for the second time.
Since 2006 it is pending.
2006 it is pending. But I'll explain the entire timeline. Lordship, you kindly hear me for some time. I'll
And
explain the entire timeline.
is there any stay operating?
There is no direct stay, but the petitioner has been directed not to appear before the trial court till the pendency of this case. In case of issuance of any summons, the petitioner has been given the protection of not appearing before the learned trial.
Show me
That
the
order,
order.
your lordships. My lord.
Not appearing into order.
My lord, I'll show that order. Your lordship may kindly have a glance at order dated 29/8/2006. 29/8/2006.
29/8/2006.
29/8/2006.
Mhm. 29/8.
Since the lower court record had been summoned, which has been received and here in the court custody, no useful purpose will be served in case the petitioner appears before the court below. Therefore, it is directed that until further, the petitioner need not appear before the court.
No, because trial court record had been summoned here.
Yes, ma'am.
But now that system is no more available. Then
Till then, this is what the order
whether
was.
trial court record is still here or it has
No,
gone.
my lord. I have filed an IA to call for the trial court record, but it is not required because I have already filed all the documents that is necessary.
Thereafter you didn't go.
My lord?
You didn't appear in the trial court.
No, my lord, I have not appeared for the trial.
Well, see, the court says that since trial court records are summoned here and there is no point going there, so therefore you need not go. But since trial court records are not there, here this court, and it might have gone back. So why have you not appeared?
No, my lord. The case is that.
Answer this first. Why have you not appeared before the trial court?
No, my lord.
From 2006 onwards.
From 2006, the summons was issued.
Hmm?
Subsequent to that, this case has been continuing till date.
I understand,
till
but
now.
there was no stay.
There was no direct statement.
Direct stay.
There was no direct stay.
And you are
2006
taking advantage of this order since then, 2006 to
Yes.
20 years.
My lord, it was.
It's very interesting.
My lord, what the issue is.
For
right-
20 years.
I humbly submit, my lord. In this case, my lord, this is a very peculiar case, my lord.
Now, whatever may be peculiarity, if there is no stay, you should have, the trial court might have proceeded.
No, the trial court has not. We have obtained instructions from the learned trial court. We have not proceeded. The case is at where it was since 2006.
When this matter was listed.
Because of this order, you took advantage of this order.
No, my lord. My lord, I believe I am the millionth counsel who is appearing in this case because a lot of counsels have appeared and it's a voluminous file. My lord.
What kind of order? I don't understand.
My lord, I'll take your lordship. I'll take your lordship through the entire case.
Yes.
What happened in this case
Lordships,
is
before that, before that, your
Yes.
lordships, when this matter was last listed, your lordships, two questions came, your lordships. Number one, your lordships, whether the delay is attributable to him or not. He has to explain. Number two, your lordships, time and again he's making a statement that there is a stay order operating. There is no direct or indirect stay, your lordships. This is also
There is no stay order.
Or
According to me,
indirect
there
stay
is
also,
no
your
stay.
lordships. He's saying that there is an indirect stay. There is no concept of indirect stay in CRPC, your lordships.
But why have you not moved any application since 2006? This is going on. You have not complained. After 20 years, you are coming and complaining.
my learned senior has.
If there was no stay, you should have proceeded with.
I'll explain, your lordships. I will explain, your lordships. Your lordships.
But let us understand the matter itself. We will dispose it up right now.
Yes.
Let us. What is this matter? Forget about the stay and all.
What happened, my lord, in this case was that this entire case culminated in the year 1999. The date of incident was allegedly in the year 1999, pursuant to which, I've prepared a date chart, my lord, this will assist you.
Yes.
On the basis of a news item in the year 1999, in the morning edition of Sambar, the chairperson of the State Women Commission filed a report to the government on an incident without examining the witness, without even meeting the victim. It was with respect to a attempt to rape that had happened in Krishna Tower, my lord. Pursuant to which, one alleged victim appears on 28/7/1999 and swears an affidavit before the executive magistrate denying her involvement in the said case. Subsequent to that, on 29/7/1999, she files a letter petition, which was subsequently registered as OJ 9456 of 1999,
and it was submitted to the Honorable Acting Chief Justice as he was there. And she states with the following prayer to quash the report of the State Women Commission, direct the government to take action against the chairperson and compensation for the damages to her reputation. Inquiry was conducted.
Who has filed this letter petition?
The alleged victim in this case.
Victim filed.
Madam. Subsequent to which, OJC number 9456 at serial number 7, if your lordship can have a glance, was disposed of, directing that no investigation so far as it relates to the involvement of the petitioner. Subsequent to which, 2 social workers filed 2 other writ applications on 30/9/1999, 11/10/1999, serial number 8 and 9.
These filed by one doctor.
One Dr. Suprabhat Das and another Prashant Kumar Das.
Yes.
They are 2 social workers.
CBI inquiry.
My lord, for CBI inquiry. Pursuant to which, this Honorable Court recalled the order passed in OJC number 9456, clubbed all the 3 writ applications and directed the CBI to register an FIR and to commence with the investigation.
Yes.
My lord. Pursuant to which FIR was registered on 7/7/2000. Serial number 15, page number 4. FIR was registered.
Yes.
Pursuant to which CBI, and this case was monitored by this Honorable High Court also. Therefore, CBI time to time filed status report before this Honorable Court.
Yes.
2 status reports were filed by the CBI before this Honorable Court. I will bring your lordship's attention to page number 9 of my date chart. Serial number 28. CBI submits the first final status report in the High Court stating that no evidence directly linking the present petitioner or any other person has come on record and investigation is concluded. Second final status report was filed on 12/2/2004 in serial number 31. CBI filed second final status report in the High Court stating that the evidence collected is insufficient to proceed the present petition.
Yes.
Well, in the meantime, CBI also filed charge sheet against other accused persons before the learned trial court, and ultimately the CBI on 21/6/2005.
When the charge sheet was filed?
Well, charge sheet was filed.
What is this after the final second final form was filed? Again,
27/9/2001.
Charge sheet was filed.
1 minute.
27/9/2000.
1 minute. 12/2/2004, the second final status report was filed,
My lord.
closing the case.
Before the Honorable High Court that no evidence linking the present petitioner has come on record.
Yes. It
Because
is a status.
it was a High Court
It is a status report. It is not a
status.
not final form.
No,
It's a status report.
Subsequently,
1 minute status report. Let us go. Status report. Second status report.
second status.
That is the second status report filed on 12/2/2004.
At serial.
And thereafter, on 8/10/2004, 164 statement is recorded. Before 164 statement was recorded,
Well,
how the status was filed in a 376 case?
no, this was the status report. 164 statement. This is the second 164 statement.
Whatever it is.
Before that, there has been record.
Show me when the first
Well,
status,
well.
164 statement.
Your lordship may kindly have a glance.
Yes. When in the date chart for me,
Yes,
when
my lord, in the date chart itself.
when the
My lord.
164 statement
My lord.
recorded.
Your lordship may kindly have a glance at serial 21, page number 5. 3/8/2001.
21.
3/8/2001.
Yes.
Status
164.
reports.
Hmm.
Your lordship was found.
Yes, status report.
Status
for
report.
investigation of CBI from
Substances perused by Honorable Court in response to query of Honorable Court. CBI officer stated that despite the best effort, no cooperation is received from the victim who is not making herself available. Then comes 10/8/2001. The very next serial number 22. Her 161 statement was recorded by CBI at Daliso.
Come 25. Come to 25.
Well, 25.
Copies of 161 and 164 statement of who the so and so
Yes, ma'am.
produced before CBI.
Yes, ma'am.
CBI before this honorable court,
Yes,
and observation made in the final. That means in the
So 164 statement was
and
recorded.
164 statement was already there.
Yes.
And on the basis of those 164 statement, you file a report before this court. And then a second 164 was recorded there on October 2004.
8
Yes.
October 2024.
Yes.
After that, my lord, the charge sheet was filed. No, my lord. After that, the closure report was filed against the present petitioner, stating that no evidence attributable to the present petitioner has come on record. And the closure report was filed on 21/6/2005.
21.
Serial number 36.
Closure report.
Closure report was filed. In this case, after the closure report was filed,
The protest petition filed.
protest petition was filed by the alleged informant. There were two informants in this case allegedly, because both the social workers were informed by the CBI in this case. So one of them turned up, Prashant Kumar Das turned up, Dr. Suprabha Das did not turn up to file any protest petition. She did not participate. Prashant Kumar Das turned up, he filed a protest petition, he filed list of documents before this honorable court, and the learned CJM rejecting the
So then there are parallel version. The one version is the victim's version, another version is the so-called informant's version.
Yes.
The victim version doesn't support the prosecution,
No, ma'am.
whereas the so-called complainants, social workers,
Yes, ma'am.
their version supports the prosecution.
Yes.
This is what is story.
Yes, ma'am.
Yes.
And this present petitioner, he was the private secretary to the then Chief Minister Girdhar Kumar. So therefore, being such an influential figure as well as an IS officer, senior most IS officer, this allegation that has been brought against him is completely a political vendetta, and it has nothing to do with his involvement in this present case for the least to be said. Because his involvement has never been uttered. His involvement in this case is absolutely minuscule, if not completely negative. What my humble submission is that, my lord, the learned magistrate took cognizance for a second time on the protest petition, instead of following chapter 15 of the CRPC by treating this as a complaint case. That is my sole contention with respect to...
The cognizance is taken in 3/7/2006.
Cognizance is taken, my lord.
3/7/2006.
Cognizance was taken once it was taken in 28/9/2001, serial number 27, page 9. 27, page 9. Cognizance was taken of the offences once on 28/9/2001.
27.
Serial number 27 of my case. Under section 120B and other allied offences, majorly 376, 511 IPC. Cognizance was again taken on this.
So then, if on 28/9/2001 cognizance is taken, how is he files the status report saying nothing there?
No, but against me. Only against the present petition.
This is against?
This is against other accused persons.
Okay,
Three
other-
other accused persons. One Pravasini Kaur, one Sushant Kumar.
What happened to the cases against them?
Cases against them is still pending.
What is the status?
The state, it is tied up with my case only. It has not proceeded. I mean,
It is listed today.
no, madam.
Then?
No, they have not filed any application.
What is happening to their trial? That's what I'm asking.
The trial is it pending at the stage as it was in 2006.
No, in your case there was a stay, indirect stay, whatever. But in the cases,
There the trial was not split up, my lord. As per my instructions, they are in the same page as me before the learned trial.
what is the other two cases tagged with this?
Other two cases is that there was a contempt proceeding initiated interestingly by this honorable court against the victim. The Lordship may kindly have a glance at this order. I have an order for your Lordship's ready referral. This is a order dated 30.
Yes.
Order dated 30/1/2018.
See,
Bald, wild, and scandalous allegations were brought against many high dignitaries and this honorable court also by the victim, because of which this contempt was initiated against the victim.
she did.
She is mentioning certain facts, which is not right on my part. It has been recorded, my lord. I'll take your lordship's attention to page number
2. Para 2.
Para 2, more well described. It has been described throughout the order. Para 3 also.
What is the application number? Contempt petition. What is the application number?
Application order date.
But contempt petition number?
Contempt petition number is 2/2018. CONTR 2/2018.
All the characters involved in this case are very contagious.
Also, have a glance at para 11 also. So this is what
She is supposed to be the victim.
yes, my lord. And my lord, one more fact is that she has filed multiple IAs before this honorable court. In one IA, she is stating that she was made a scapegoat and she had nothing to do regarding her involvement in this case. And on this very next IA, she is doing that IA, and she is again filing an IA for intervention. I have also mentioned the IA numbers. Tons of IAs. Ultimately, she was impleaded as a party in 2017, pursuant to which she has made these allegations against dignitaries. After multiple IAs since 2016, this was the final IA. All the IAs were dismissed.
Yes, Mr. Naik, what do you say?
This is.
Lordship, you were supposed to read 164 statement dated 8/10/2004, your lordships.
8/10/2004.
2004.
Where is that?
The 164 statement he was supposed to read, he can read, your lordships. Second
Where?
164 statement dated, he had filed it, your lordships, in page 26.
Page 26.
He had given me a bunch of documents, your lordships. In page 26 is the 164 statements, your lordships, of Harapriya Barik, the second 164.
Where is that 164? Show me. 164.
There are two 164 statements.
The second one. Second one. 2004 164 statement. After your status filed, the CBA filed before this court. After that.
Because if your lordships, after the giving of the closure report, if the magistrate doesn't accept it and still takes cognizance when a contempt petition is pending in the High Court, your lordships, the magistrate might have perused these documents, including the 164 statement, your lordships.
Show me. Read it.
He can read.
That is my copy that I
164.
We already filed 164.
But you can read it. You can
Let us see. Where is that?
Yes, sir.
Bottom.
Yes.
Lordship, kindly, for just once.
I was a student of Kuntala Kumari Sabat College, Balesore.
So you page 26. Where are you showing it? Let us see the document from here, from the record. Where is that, Mr. Naik?
He has filed it, your lordship. Those documents he gave me to me.
Page, which page?
In my document, it is page 26, your lordship. Statement of
Annexure?
Harapriya Barik.
Annexure?
Okay.
Page 26.
Okay. .
No, something else.
He can give you lordship 164 statement only.
This one he is
has it,
reading.
your lordships.
This one he is.
I have already given a copy.
Let us see. Yes.
I was a student of Kuntala Kumari Sabat College, Balesore. On 7/7/1999, at the time, Sri Prabhasini Kar took me to Bhubaneswar on the pretext of providing me a job. Siddharth Patra took me and Prabhasini Kar took
This is not what you are reading.
So, lordships, the 164 dated 8/10/2004 was provided to me by the council only, your lordships.
I don't know. From record, you have to show me. Where is that 160?
He can lordships.
From record.
But in spite of whatever
No, your
has been
lordships,
stated
lordships
in the
are
last
asking to-
statement, they have given me a clean sheet 5 times.
Why this is matter is pending since last 26 years, you know? Because of this, the manner in which you are arguing. Show me the paper, I'll dispose of today. So 26 years, nothing is happening. You are not able to show me the pages. What is this? Hard copy.
8/10/2004. 8/10/2004.
Yes, yes.
Yes, 8/10/2004.
The hard copy, my copy. Yes.
One second.
Your lordships, I would like to fairly submit that on 21/6/2005.
See the volume. Deliberately, this has been done like this. There is nothing in this matter. It can be disposed of within few minutes to me.
Yes, your lordships.
Yes, sir.
Your lordships
How
on
many volume? How many volume? Huh? Yes, see. Deliberately, this is created so that with this confusion, no court will see this file and it will be remain pending for years together and take advantage.
My lord, I am not taking, I am the one who is putting all the endeavor to get it listed.
Okay, show me now. 162. Show me.
he can read your lordships 164.
8/10/2004.
8/10.
2004. I have the translated copy of that second 164 statement.
It is your petition. You must show me the papers.
Yes, well, I have it. I have the
From the record, you show me so many documents you have filed. Show me from the record where you have filed.
But I have already filed last page.
Lordship may list it after 2 weeks. Lordship may list it after 2 weeks. Let him, your lordship, organize all the papers. Then your lordship.
No,
I have filed before this.
I have spent time and I want to read it.
Yes.
Copy of my learned signal.
Then let him read it, your lordships. The second.
I'll read the translated version. Page number 30. Statement of Hon'Ble under 164 dated 8/10/2004.
Your lordship, the original may be read, your lordship. We don't know who has translated it, whether he's an official translator or not. You read in Odia. We don't know, your lordship, who is the translator, whether he's official or he has translated it. The real meaning may be diluted, your lordships.
Mr. Naik, the problem is neither you are properly ready, nor he is.
I am ready, your lordship. Ask many questions. I am completely ready, your lordship.
In this manner, the hearing can't take place. You know,
Your
you show
lordship,
me the
your lordship,
pages.
CBI had, your lordship, CBI had filed a
Thousands
closure
and
report.
thousand pages documents are filed. You are not able to show me
your
the.
lordships. The court asked him to file documents. He never did it, your lordships.
Page 77 is the, 77 is the 161 statement.
70?
777.
No, 164, not 161, 164.
All judgments and all.
Your lordship, I have read the file entirely, your lordship. I don't know without preparation, your lordship.
Over the 164 statement.
This is no way.
I'm handing over the statement.
Whether
Because
the
the court
record-
had asked him earlier that you read the second 164 statement. Till now, he's not reading it.
Yes. Let me see that. It's really.
And your lordship, the magistrate is not bound to accept the closure report. The magistrate can always take cognizance if he feels that.
Yes, the magistrate can take on it, but not twice. That is my humble.
It starts with, your lordship, I was a student of Kuntala Kumari Sabat College, Balesore. On 7/7/1999, at the time, Prabhasini Kar took me to Bhubaneswar on the pretext of providing me job. Lordship, it starts with that. Siddharth Patra took me and Pravasini Kar to Baleshwar bus stand in Maruti car. From there, I and Pravasini Kar.
16/8/2001, there is one 164 statement.
Yes.
16.
This is the second 164 statement. I have provided the second 164 statement. I'll read that 164 statement.
That is dated
8/10/2004. 8/10/2004.
1 minute.
Second 164 statement.
It is there.
Yes.
I got it. With ODI also I have. Yes.
Well, I was a student of Kuntala Kumari Sabat College, Baleshwar on such and such date. At the time, Srimati Pravasini Kaur took me to Bhubaneswar on the pretext of fighting her. Siddharth Patra took me and Pravasini Kaur to Baleshwar.
Your Lordships, just 1 minute, Your Lordships. Your Lordships, it also contains the name of current advocates of this High Court, Your Lordships. Those names may be skipped, Your Lordships.
He will not read. Yes, I know. He will not read that. He will not read that. Yes.
From there, I and Pravasini Kaur proceeded in a bus and reached at Krishna Tower situated at Bhubaneswar. There, Sushant Mahapatra and Pravasini Kaur consumed liquor. Thereafter, Sushant attempted to outrage any modesty by exhibiting blue film. I confined myself in the toilet and heard from inside Pravasini Kaur telling Sushant that Prashant is at downstairs. Deny him, the girl is not willing. This is the thing that she has stated in the 164 statement. I returned back to Baleshwar being escaped. Mohila Commission submitted investigation into the matter. Thereafter, Rabindra Sahu, Siddharth Patra, Pravasini Kaur, Sushant Mahapatra, Munna Mahapatra came to our house and threatened me as well as my family members not to disclose this fact elsewhere. In case of disclosure of the above facts, they told me to do away with my life as well as the lives of my family members and also to hurl bomb to my house. On 28/7/99, they forced me to swear one false affidavit and brought me to Qatar from Baleshwar. On the way to Bhadrak, they took in a vehicle and reached at the residence of such and such. They lifted such and such and took to court of the executive magistrate. The accused persons and my mother proceeded to the court of the magistrate along with me. I and my mother went inside the chamber and submitted the false affidavit. All others are remaining outside. Thereafter, we all came to the residence of such and such. While I was inside the car, they obtained my signatures on several plain papers, putting date on several written papers, and also got written some letters by me. Then on our way to Bhubaneswar, such and such boarded our vehicle at Purighat and went to Samaj office at Bhubaneswar. Such and such was ready and the arrangements for a press meeting there. They got written from me and made me told there that no such incident has happened on such and such. They accompanied me and mother in a dharmashala at Puri. On this date, they told me that the above matter will be informed to the such and such through a writ petition, and on that day, the accused persons took me to the Honorable High Court. They all remained outside. Myself and mother and such and such submitted false writ petition. After coming to the downstairs, such and such pointed towards the petitioner, told me that the above man can kill and save life if he desires. It will not be wise to create enmity with him. After all the incident, I got married to such and such and lived happy. But on 25/8/2001, the above people obtained signatures on white papers by threatening. When such and such bail application was rejected, they came to me and threatened and compelled me to write a letter to such and such, and further that there will now be no problem for me. But the accused person can get bail. I received a notice from...
Who is appearing for the girl, victim lady? See, all these things happened in 2000. Many lawyers' name, lawyer name, everybody is being implicated here. Who is appearing for that girl? I will issue notice, letter come.
My name is Jayendra.
You are appearing?
Yes.
For that lady?
Yes.
Have you taken instruction? Is she still insisting to continue with this? Have you spoken to her?
No, madam.
Speak to her. Whether she is interested to continue.
Yes.
Because see, this incident happened in 2099 and all. She was that time about 47 years or something. Must be in the 60s. But she's serious making such allegations. And she every now and then she changes her statement. Every now and then. And it's very easy to make allegation against all, lawyers and all.
Also, one FIR is lodged at Lalwag PS, madam.
Against?
That I'm finding, madam.
So therefore, she has already messed up.
It is in the record, madam. Therefore,
She's already messed up. You seek instruction from her, whether she is interested to continue or not. If she is not interested to continue, then we'll drop
I had filed an miss case for intervention matter.
Intervention, you are already opinion, but
Yes.
You seek instruction. I'm
Yes.
just Mr. Mishra appearing for the victim in the present case. Seek an adjournment to obtain instruction from her and apply the court as to whether he is still willing to continue the prosecution or and release the matter on today's 17th, 24th, next Monday.
It's out ticket.
No, why? 24th. I have heard it.
It is of matter 2017. I have no contact.
This thing, would you go try it?
Page 588 matter. One FIR is lodged in Lalbagh PS.
So as if you see her stand, every now and then she is changing. Therefore, she made the CBI people also confused. So sometimes they file status report saying that nothing has happened. Next time again 164.
At that time it was
She makes another statement. Then and see her a contempt petition. See the order. She making allegation against the all the lawyers. If we see serious about this case, you ask her and let her file an affidavit.
Yes.
Okay. 24th.
Well, I am permitted to take in the TCR matter.
Yes.
All this.
Mr. Mishra is permitted to obtain the records. Soft copy of the records. Yes.
one last.
And in the meantime, let counsel appearing for the petition shall file a convenient volume. Convenient volume. Prepare a convenient volume. All the relevant documents and all. And I'll rely upon that paperwork. And you get the instruction 24th.
A copy may be given to me, Your Lordships.
Yes. Yes, Mr. Naik.
Your Lordship, a copy of the convenient compilation may be given to me.
Yeah, compilation. Let him prepare a compilation. That will be easier thing. And you circulate the compilation.
I will give a copy.
Yes.
One last thing.
Hopefully, Your Lordships. Hopefully, Your Lordship, it doesn't become the 12th council because 11 has already. Next time, you should come, Your Lordships.
No, to 24th, I'll dispose it up.
Yes, Your Lordship. Because the yes.
Yes.
No, I will.
Yes.
In the first title, lots of names of all the previous council and in the orders also their names are being reflected and in the cost title also it is being reflected. So they have requested me make a mention for removal of their names.
Whose name is to be removed?
My lord, Mr. Sorry, ma'am's name, Mr.
Sankar Naik and oh, here, bro. Mr. Mishra. You know, answer is yes. Rest of the except these three names. Give in writing.
Name of Soda Pradhan may be deleted. He is no more.
He is no more. Yes.
Obliged.
Yes.
95.
What happened? So IAC logged the FIR for this one and they investigated the cell and submitted also charge. And so far offense is concerned, that is 7 cases. Because the results released there, will take the case.
Okay.
Well, our shortage
And this matter is going on since last.
I want the shortage side sir, PCR to vigilance is there. I have also
The last opportunity is sought by counsel for the position to address the matter. Please the Least in last paper. Yes. Yes.
96.
If you are asking that for the matter to mediation,
Mhm.
my client could not attend. The possibility of found from having husband had left this motor world. Now this lady with the minor child could not. I have requested twice and no money at all. In fact, I offered and sending you some money.
Didn't they?
Yeah,
What
what
I
is-
propose under this circumstance, it was stated before your lordship in 2023, the parties are agreed. Yet it concluded there at Holy Court where the case is pending, all of them belongs to there. They will go and do. It's now copy of the law.
Under Annex 3, before the village also the party do are compromise.
what is the offense? What is the offense?
498 and other offences.
Hmm.
There is substance and what the document.
What are you seeking here? You are
No, I am not seeking, madam. I
Then?
am complainant of the.
okay.
In the meantime, my husband has also died.
The main accused man is the husband man. Can you take away another lady man? Or who is your FIR has been lodged?
No, what is this FIR? 2014 FIR. Cognizance order is 2014.
Fine. Because to impress, if you are saying that everything is settled, you impress your daughter-in-law or sister-in-law. Because you have the mother-in-law and brother-in-law. That's who real accident.
Hmm.
Can you not impress her who is staying next to you? And after the demise of the husband, the last time, also you could annex the.
Anything survives?
Huh?
Husband?
No, that question the lawsuit should have been put. My husband has died.
Hmm.
I am the informant victim. She could not join the mediation because of paucity of fund.
No, are you serious really?
My lord,
Against your in-laws? Your husband died.
my lord,
What survives?
my lord, she is ready to continue the proceeding, provided some arrangement is made as per the agreement appended to this application. There is no such development.
Let us see the
That arrangement that is.
see the cognizance order.
My lord.
Cognizance order. Cognizance.
They only relied on the village agreement executed because of village people. Have you got anything with regard to whatever written there? I have asked nothing.
Show me the charge sheet.
That's it in that. In fact, the base 31 would be relevant.
30?
31.
One, yes.
Concluding portion of the.
Let us see. It should be made of no allegations. Let us see. On that, they also during the course of investigating this court, examining the complaint and witness conducting the frequent raid in the house of the accused persons and apprehended namely forward them in the infant she the dowry of the
Stage operating since long. And you said that you will take care to file affidavit, joint affidavit.
More than 6 to 7 years, now they have a complement the likely with your.
Dita pinda ଅଛନ୍ତି ଯେ ସେଇଟା ପାଇଁ ପୁଲିସ ଅଛନ୍ତି କଣ? You accept
498A and 4DP Act. Cognizance is taken for offense under section 498A, 406, 394, 494, 34 IPC and 4DP Act.
Yes.
Next, the petition number 1 is the mother-in-law.
Mongol Patra and D.
And number 2 is?
Here. Here.
What are the material against them?
Material against they have all demanded dowry.
Where is that? Show me.
That
161.
They have blown her away from the. I'm
Let us-
taking your lawsuit.
Let us see the evidence.
FIR is an Annex 2.
Let us see. What are the allegations against these two people?
Since your lawsuit may at a glance, I'm not supposed to read out to.
Where is that? Paragraph?
Page 19, 19.
Just since 10 years back, the complainant had got to make it to the
Fine.
all formalities. Para?
5 and 6 is
Five.
relevant.
That gradually the accused number 1 secretly started To develop accused number 1 is Arjun. He accused number Ganesh. Hey, 1 minute. एक मिनट. जानकी and Ganesh. ठीक है? Janki and Ganesh. 1 minute. Janki and Ganesh. Janki and Ganesh. एक मिनट. Janki and Ganesh. 3 and 4. ठीक है? 3 and 4. 3 and 4. Let us see. Where is the allegation against 3 and 4?
3 and 4 is my lord, page 20.
20, yes.
That paragraph 5.
Yes. It is, all allegations are against accused number 1, who is the husband, who died. Where is that? All, see, the general, how, unless specific allegations are there, how cognizance is taken like this?
And moreover.
No, where, show me any allegation against 3 and 4.
Yes, yes. The paragraph number 6.
6.
That in the meantime, accused number 1 being instigated by all other accused person married to said partner for second time through though the matrimonial relationship in between the complainant.
Oh, this is very
The complainant brought the matter before the village entities, but when they failed to subside the matter, the complainant reported. And previous to that, she has stated accused number 1 will again get married to the said partner, and saying
there is no specific government.
They all assaulted her and drove the complainant out of their house on 21/1/2014 night at 3 p.m.
There is no specific overtake attributed to these two people.
They drove away, by not assaulted and drove away.
I think you have to stop here. The husband died, and this is.
And there is no protection. It's not protection.
But this is not the proceeding. Have you moved any application, DP Act or something?
You must see. Page 33 and 32 and 33.
30?
Just have a glance, and I left it to your lordship.
31.
32 and 33.
Yes, 32, 33. Yes.
33 would be. These are the agreement. They rely on this agreement. What the stay matter is.
Yes. Yes, let us see. Who has signed this agreement?
I have also signed. They have also signed.
Let us see. They means who?
What is the agreement?
Arjun Patra. And who has signed? The Janki? Janki has signed?
Yes. LPA of the.
Yes. What is agreed?
Agreed page 33. 33. 33 of it.
Yes, read.
ଆଜିଠାରୁ ଘର ବାଡ଼ି ପତ୍ର ଇତ୍ୟାଦି ହଣାହଣି ଅଗ୍ରାଧିକାର ଜବରଦଖଲ କରିବୁ ନାହିଁ, କାହାର ନିଜସ୍ୱ ସମ୍ପତ୍ତି ଉପରେ ଜବରଦଖଲ କରିବୁ ନାହିଁ। This is all against the wife. ଉପରୋକ୍ତ ବଣ୍ଟନ ସମ୍ପତ୍ତି ଛଡା ପିତାଙ୍କ ଅଧୀନରେ ଥିବା ପିତା ତାଙ୍କର ଅଧୀନରେ ଥିବା ସମ୍ପତ୍ତି ଉପରେ ଅନ୍ୟ କୌଣସି ପକ୍ଷ ପିତା ମାତାଙ୍କର ବିନା ଇଚ୍ଛାରେ ଦଖଲ କରିବେ ନାହିଁ। To eliminate all these three things.
But you have signed it. What to do?
Your imagine. So what I was saying? Let them go impress. Why did they?
I'll pass the order.
You know, the stay
I'll pass the order.
Ultimately, they will.
So nothing is going to happen. Unnecessary. This is wastage of time.
That is what I say.
And once I refer the matter to the mediation, at least you should have participated. You didn't participate.
What is the reality, madam?
Why should the court will be troubled for the?
She is a daily level, having 3 children, driven away by the in-laws.
What is today? The husband has died. What will happen? See, the mother-in-law is in her 70s or 80s, in the deathbed, and you want to prosecute them.
Deathbed was the allegation in 2014, and
today, what is this?
So what sorts of deathbed your lordship can
I don't think so. 12 वर्ष 498 case and husband died. Allegation, general allegation against the mother-in-law and sister-in-law. How far you will get?
Even I am not there, man. What I was.
I gave an opportunity for settlement. You didn't do that.
It is difficult for her to come to Qatar, being the daily laborer. Even
I passed this order at your instance.
No, I have come they suggested from CORAM, man.
I don't see your consent is written here. I myself have written. I don't know what happened that day.
Said CORAM. Thereafter, your lawyer said at Qatar. I said I will insist upon, and I was ready to send even some money, but it is the difficulty. I said from very beginning.
Then Spain violated 10 years.
Which court is that? Which court is that?
Drop of the plight.
Which court is that? Court, judicial magistrate, Court. And the mediation center is in at Barampur. Barampur also they won't come. I know.
Once she can go 30 kilometers.
But what will you get? See, the mother.
At least some
1 minute.
Nothing else, man.
Try to appreciate who will give you. Mother-in-law is at 70. Do you expect anything from her?
They are expecting through annexure this agreement from me.
See, the agreement is neither here nor there.
That is how they have realized.
And number two is the brother-in-law. He might have his own family.
Here I have no objection saying that I know, and the recent judgments are series of judgments are unnecessarily entangling. I am conscious.
I'll pass the order.
Conscious.
I'll pass the order.
What about the plight of the 3 child?
I'll pass the order. Yes.
And in cases also, this honorable court as well as appellate court also made some observation or remark to see the at least the protection of this.
We'll see.
In that light, the observation. So far as punishing is not the outcome of his
This is not the petition for that.
Punishment we never do any.
So can I grant these kind of relief? Then.
But there are some instances where the court has taken cognizance of the plight of a person.
Next slide. Yes.
97 mentioned. 97 he is asking for time. I don't know that's an objection. Only thing I will say, till 29/7/2026, financial establishment has not been made an accused. Director is being prosecuted on the basis of a deeming clause without the financial establishment being made an accused. That's my commission.
But he was thinking
time. I am not opposing that.
No, we'll see. Please it good something the query. Yes.
98.
Give a date. Yes. Yes.
98, there was some order, my lordship. Kindly have a glance to the order dated 22/2023.
Is there any chance of conciliation? Who is appearing for the? Who is appearing? You are appearing for opposite party number 2. Huh? Who is appearing for petitioner? What is this petition?
This is of 376/2
You are appearing for the petitioner. Is there any scope of settlement? Don't ask adjournment routinely.
My lord, interim still vacated.
No, the court has recorded that there is a chance settlement.
Conciliation.
Is there any chance? What do you say? No chance.
This is a case of 3.
Our married. Victim is married since 2020.
Both of you what? So then there is a chance of settlement.
Yes.
Shall I send it to mediation? Shall I send it for mediation?
Yes.
Is there any chance of settlement? in mediation, the coordinated bench of this court on while hearing the matter on Kodiyadu Jardesi had it indicated that after hearing the parties have indicated that there is a chance of reconciliation in the matter. The counsel appearing for the parties have also expressed the same concern. They have also submitted that both the petitioner and opposite party have already married separately and leading peaceful crime. In view of the same, there is a scope of the matter being settled through mediation. Hence, shall I send it to local mediation center or High Court mediation center? Local mediation center, Sundargarh.
High Court
mediation center, Sundargarh. Sundargarh. And awaiting the report, release the matter in October. Yes. Yes.
99.
Yes. Yes.
I am accused in one case. And the petitioner. Complainant's evidence is before defense evidence could commence. I filed an application that the procedure should be through summary procedure because the incumbent in the court has changed, so he cannot rely on the evidences recorded by his predecessor. That is necessarily on 143 of the NI Act, which says that the procedure is mandatorily of a summary. That petition has been rejected. I rely.
Rightly.
For my humble submission, I will just cite a decision of this court.
Now, recent decision you see. Justice Monmouth. You want to cite some decision, you show me.
That was of 2013.
Now, much water has gone under the bridge. Now, the situation is in 138 case, this procedure is rightly followed. And better 2015 complaint case, today we are in 2026. What is the check amount?
Check amount to 15 lakhs.
Show me the impugn order.
Next one.
Yes. Relying upon the above judgment, which judgment, he argued that the case record doesn't reveal any reason order regarding the modification of the trial procedure from the summary trial to summons. So the evidence recorded by the predecessor cannot be used by the succeeding magistrate, and hence there will be no trial and so on. So they will forget for complaint of which such contention charges and so. The period of the case record is immediately that the order sheet does not contain any order regarding the modification of the trial from source. Section 143 mandate the eruption of a summary trial procedure and also makes provision for converting the trial procedure from summary to summons trial in appropriate case. Further procedure of the record, it means that yes. And the trial court also relied upon this 2014 judgment.
2013 judgment.
Yes.
And my humble submission, he has also referred to a Supreme Court decision. The only distinction is the Supreme Court decision was rendered at the upper stage after a conviction. Here I approached before commencement of my evidence. And the 143 subsection 2 says that if the magistrate
you don't have a case, will you pay the money or not? Come to the point. You are successfully avoided payment for about decade, more than a decade.
Yes.
Pay the amount, come to, tomorrow or day after with check, I'll entertain. Otherwise, I'll dismiss. With the direction to the trial court, to conclude the trial within 3 months. Come with the money so that you will be escape from the interest and compensation and all. Otherwise, you will be convicted. Simple. Don't go here and there. You know the fate of this case.
You should not dispose of the second option, which is better, let them try it.
That's better idea. Okay, I'll pass the order. I'll read it pass the order. Yes. Recent judgment of Justice Monmouth is very, very clear on this. And thereafter, so many other judgments. In appropriate case, court can the application from summary trial to a summons trial. That is a different story. But here,
That is what my application was.
yes. Anyway,
2014 decision is also not applicable to his case.
anyway, it's now high time. I'll dispose it up. Okay. Yes.
101.
Yes.
1 minute. I need to file a small reply. I had taken time. If you lordship may kindly see order number 3. The reason is order number 3. That is 9th April 2006.
Number 3.
994 minute.
Yes.
Para 2. Your lordship gets it?
Yes.
Learned counsel for the state is directed to file a reply as to why the provision of section of 133 CRPC has not been followed in letter and spirit. It seems that the learned SD and Khordha has selectively amnesia of the said provision. Pursuant thereto, one affidavit was filed by the state where they failed to show compliance of section 133.
Yes.
They failed to comply 133.
What is this complaint? The complaint is about?
A public peace, breach of public peace. That 136.
Yeah.
Yes.
They failed to comply, show compliance of 133. When that was pointed out, they came up with another reply showing compliance of the 133 provision, which was filed on 1st July 2026. That I need to take instruction that there are 2 documents they have submitted, which they had not submitted in the earlier affidavit. Now, by virtue of this affidavit, they have tried to patch up the lacuna by showing some compliance. I have to file a short reply to that.
Anything still remains in this matter?
Yes, Malaj. There is an interim order because there is an interim order. The entire case, of the
on facts, what is the case?
The fact is that there is a dispute pertains between the present petitioner and the private opposite party. Both FIR and counter FIR filed. They filed an application for removal of unauthorized construction allegedly done by me under section 133. My entire case is that 133 has some conditions, Malaj. First show cause, inquiry, conditional order. If I fail to remove, then the final order. Here, Malaj, nothing has been done. I was not given an opportunity. Therefore, this honorable court was of the view that 133 compliance is to be shown by the state. They filed a reply to that. Did not show compliance. I point after they have filed another reply, while that reply is still on record, not withdrawn. They have filed another reply.
That reply.
Let me complete sentence. Yes.
Malaj. So now
subsequent reply, they say that we have complied.
That is not stricto facto compliance of 133 also, but they have annexed 2-3 documents which was not annexed to the earlier reply. So when this honorable court pointed out that it doesn't amount to strict compliance, they came up with another reply. So those 2 documents which they have now annexed in the recent reply, I need to revert to that document to confer to the client whether these have been issued to them or not.
When they filed the reply?
Malaj, they have filed the reply at page number.
Second reply.
The second reply. That would be Malaj at flag
1/7/2026.
July they filed. July.
Yes, Malaj. Malaj, all I need is 2 days time. They have assured me to come on Sunday, last Sunday, but they didn't come.
But the earlier reply we have withdrawn, madam.
Mr. Marana, the counsel appearing for the petitioner submits that in the second affidavit filed by the state on 1/7/2026, certain documents have been relied upon. He seeks an adjournment to obtain instruction from his client about those documents. He may do so within a week. Least the matter on 28th of September.
As you know.
Yes. Human rights.
Interim order to continue.
Interim order to continue. Yes.
102.
Yes.
For the opposite party, my lord, that mediation failed due to non-appearance of the petitioners, my lord.
Who is for petitioners? Mediation. Mediation report has come.
Like it's a
report
mediation report.
submitted. Petitioners are absent today. What is this petition?
And a petition, they have challenged the order of cognizance, my lord.
Where is that order? Where is that order?
Cognizance order is at page, my lord.
Annexure 5,
Annexure 5.
page number 52.
55, my lord.
It started from 52.
56 is
Cognizance.
the 56.
50?
This is the order.
Is the order.
That is 12/2/2024.
420. It is arising out of a civil dispute. It is arising out of a civil dispute, and they are the nephew and the uncle, madam.
Whoever it is, but once it was sent for mediation, you don't appear. And
And twice they have taken money. Once they have handed over to the victim and second.
by the order dated 22/7/2026, on 22/7/2026, when the matter was heard by this court on the consent of the parties, the matter was referred to mediation. The High Court Mediation Center has filed a report dated 12/8/2026. The report reveals that the petitioners remain continuously absent from the mediation process. It is very fortunate after a consent order was passed by this court on 22/7/2026, referring the matter for mediation. Neither the counsel for the petitioner nor the petitioner appear before the mediation center. When the matter is taken up today, none appears for the petitioner. In view of the same, the present petition stands dismissed. Yes.
Interim order was there. That
Petition is dismissed.
the report sometimes court.
Accordingly, the interim order passed earlier also stands vacant. Yes.
103.
May please, Lordship. Item 100, I pray for an adjournment, Lordship. Because there is a mutual settlement, Lordship, but I have no idea. So I pray for an adjournment, Lordship. As you, Lordship, already know that.
On last proposal, but there was no complement. Your Lordship will find on the basis of false absorption that there is settlement within the parties. The notice has been issued and matter is proceeded.
What is this matter?
And extra 5, your Lordship will find that is the opposite petitioners. They have fraudulently created sell deed in personally me that I have sold that my property to them.
You are appearing for opposite party.
Opposite too.
Yes.
And accordingly, FIR was lost and under section 384,
Yes.
right, to the BNS Act.
The quashing of the FIR.
They are setting entire proceeding.
Investigation is going on.
Yes, sir.
Investigation?
No, if tax has not been submitted.
Okay.
Because of the pendants of the duty, the pendants of this application.
No, there is no stay.
No
There is
stay there.
Then
However,
what is the stage of
We
investigation?
have to take the instruction because second time my lawsuit will come to. Last occasion they said that settled the matter. That's why your lordship was directed to the part number 2. Then on next day we could.
I have also denied
Matter has already been said. No, it's not. The last date of hearing. The last date of hearing, counsel appearing for the petitioner has submitted that the matter has already been settled. However, the counsel appearing for the opposite party vehemently opposes the same and submits that there is no settlement right between the parties. This is a petition seeking quashing of the FIR number so and so. Right. FIR number Delaga PS case number 295 of 2020 corresponding to GR case number 600 of 2024. It appears since there is in the absence of any stay, the investigation of the case might have proceeded substantially. However, the state council has no instruction in that regard. To obtain instruction regarding the status of the investigation, release the matter on 25th of August. You get the status? 25th of August, she will get the instruction regarding the investigation. I have recorded that there is no.
Yes, ma'am.
On that day,
That's why there is impediment to proceed with the.
I'll dismiss that day. Dismiss that day. Yes.
Board has ended what your lordship is also out of time. Item 37, may I only pray that your lordship may indicate that let it be taken up after tomorrow at 2 p.m. So that at least my.
Again, the problem is in these miscellaneous matters, 110 matters are listed every day because of lot of.
At least one matter can have a closure.
But the other current the law
Let that segregated, let them be heard in regular course. Why should my client suffer in the process? My appeal has already been heard.
That's right, but
and they stand
arising out of the same impugn judgment.
They stand on a different footing altogether.
Indicate at 3 o'clock. Huh? Indicate that matter at 3 o'clock to be taken up at 3 o'clock. 3 o'clock. Huh? 3 o'clock. Yes, indicate that 3:30. And whoever is the lawyers being corrected matter, we call them and ask.
Only the first matter, the three matters
the other two matters, no? You, the lawyers, you tell them. Okay. Your Lordship. I'll take that.